Can I take Your Honour to the final document? It's another ATAGI document. This one dated the 14th of December 2021, and it is Annexure B. Is less relevant than the one that I've just taken Your Honour to. The one that I just took Your Honour to, of course, is the very document that GPs are exhorted to apply as guidance when making assessments about what to put up on the register, which, of course, when you track back through the links in the chain that I've just taken Your Honour through, the point of which ultimately traces back to the Australian Travel Declaration, whether or not one's got a medical contraindication to COVID-19 vaccine. This second document, which is dated the 14th of December 2021, is not as directly relevant because it doesn't form a link in that chain, and moreover, it deals with a slightly different subject. The subject with which this document deals is, as the heading states, the definition of, quote, fully vaccinated. Now, to be perfectly clear, it is no part of Mr Djokovic's argument to this court, or indeed the case that he presented to the extent that he was allowed, to the officials at the airport, that he's fully vaccinated. Fully vaccinated, as explained by ATAGI, is having had a relevant number of doses of a certain number of different kinds of vaccine as they're set out. And so at the bottom of that page, we have the heading TGA approved and recognised vaccines. We can skip over that because that's not relevant here. Mr Djokovic is not vaccinated. Then we move to page number 2, or it's page 10 of the affidavit. It's headed Special Considerations for the Definition of Fully Vaccinated. There's a series of subheadings, the first few of which are not relevant. Then on the next page, we have the subheading Past SARS-CoV-2 Infection. And it's the first paragraph here that picks up what I was indicating to Your Honour earlier about what ATAGI has said is accepted as the effect of having been infected with COVID, which is that one acquires a degree of natural immunity for a period of time. So
I'm sorry, Mr Wood, where are you?
Page 3 of the 14 December 2021
yes,
guidelines.
Thank you very much. Past
Top
infection.
page, subheading, under the broader heading Special Considerations for the definition.
I have it.
Subheadings past CoV-2 infection. Look at the first paragraph. ATAGI notes that natural immunity from past infections is recognised as fully vaccinated in several European countries. ATAGI also notes the challenge of confirming past infection, in other words, as a matter of fact or as a matter of administrative practice, and uncertainty with regards to the duration of protection. But pausing there for the moment, whilst ATAGI is observing that it is recognised in other European countries as relevant to the definition of fully vaccinated, what presently matters is ATAGI's acknowledgement or recognition that natural immunity does flow from past infection. The doubts that ATAGI expresses about it, are the challenge of confirming in a given case whether someone has in fact had a past infection. That's the first point. And the second doubt is uncertainty with regards to the duration of protection. But it's abundantly clear that ATAGI is saying that having had a past infection provides, subject to questions about duration, natural immunity. Then we go to the second paragraph. It says, while evidence suggests that past infection reduces the risk of reinfection for, quote, at least 6 months. So that links with the duration doubt expressed above. ATAGI is saying evidence suggests that past infection reduces the risk of reinfection for at least 6 months. And then we get to an important bit, brackets, and therefore may be regarded as a temporary exemption from vaccination for a maximum of 6 months, which of course perfectly coheres with the 26 November 2021 document that we explored earlier, which is the ATAGI expanded guidance on acute major medical conditions, which with crystal clarity identified PCR confirmed infection within the past 6 months as being the basis for the grant of a temporary exemption. Now, what Mr Tran and Ms Wushan emphasise is the balance of that second paragraph, where it said ATAGI recommends that 2 doses of a TGA approved vaccine is still required to be considered fully vaccinated, but that's of no concern because no part of Mr Djokovic's case is that he's fully vaccinated, and indeed the delegate made no findings about the question of full vaccination with respect to Mr Djokovic. What Mr. Tran and Ms. Wootner emphasise is the final sentence in that paragraph, which says past infection with SARS-CoV-2 is not a contraindication to vaccination. But that has to be understood as a general statement qualified by what ATAGI has said with abundant clarity in the 26 November document that recent, the subcategory recent past infection is, which of course also coheres with what in the preceding paragraph ATAGI is accepting that recent infection produces, which is a degree of immunity. In any event, what we identify, Your Honour, is on page 4 of this document, which, as I emphasise, is the less important of the ATAGI guidelines. So if we move to the next page, page 4, there's a subheading that says past SARS-CoV-2 infection. And entirely consistently with the 26 November guideline document, the first paragraph says COVID-19 vaccination in people who have had a PCR-confirmed SARS-CoV-2 infection can be deferred for a maximum of 6 months after the acute illness as a temporary exemption due to, quote, acute major medical illness, which is necessarily to be regarded as a medical contraindication to the taking of the vaccine. How else could an acute major medical illness be characterised, and how could the reference there be explained otherwise than it is, in the circumstance of a recent infection, a medical contraindication to the taking of a vaccine? Now, the next paragraph acknowledges, I think it's fair to say, that people with a past infection can start their vaccination course or complete their second dose if they've already had a first dose prior to being infected, and makes a recommendation of the minimum interval. But that doesn't cut across the proposition, which is clearly put in the first paragraph, that it can be deferred as a temporary exemption due to acute major medical illness. That then leaves the final part of the puzzle, which is the table at page 5 of the same guideline, which sets out scenarios, doses, and ultimately clinical recommendations in the right-hand column. The relevant entry is the final row, left-hand column, scenario, previous infection. Then if we move to the third column, which is entitled number of doses received, look at the first bit of that final row, none. That's the case here with Mr. Djokovic. The fourth column deals with the subject with which we're not concerned. Doses required to be considered fully vaccinated. ATAGI's answer is, well, 2 doses. Fair enough. Mr. Djokovic doesn't say he's fully vaccinated. That's not the point. But we move to the relevant bit, which is the final column, clinical recommendation. In other words, advisability, picking up that notion of what medical contraindication means. Recommendation, what's the answer? Valid exemption for up to 6 months. And then we have a hashtag, in effect operating as a footnote. One moves to the bottom of the page. The hashtag says, more information can be found in ATAGI expanded guidance on temporary medical exemptions for COVID-19 vaccines, which is, of course, the 26 November 2021 document that I was just exploring, which is, of course, the more relevant document that says with abundant clarity that for all COVID-19 vaccines, PCR-confirmed infection where vaccination can be deferred until 6 months after the infection. So, to put that all in the picture of this case again, Your Honour, I remind Your Honour that the simple point on ground 1C, and it's a very simple one, that I've already discussed, is that the delegate made a positive finding that previous infection is not considered a medical contraindication. I've explained that there was no evidence identified in the reasons for that positive finding. There's no evidence before the court that there was any other evidence before the delegate that was capable of supporting that finding. I've explained to the court that the only evidence that was before the delegate was evidence that came in the form of the exemption certificate from Tennis Australia that referred to 2 eminent physicians with specialist expertise who had expressed the view that the exemption should be granted based on ATAGI guidelines. And I've said that therefore on a just vanilla analysis, application of administrative law principles, the positive finding wasn't open, and the failure to deal with the applicant's own evidence itself reveals jurisdictional error. The point of this discussion about ATAGI guidelines is to say, even if somehow, despite the absence of evidence, despite the minister not calling the delegate as a witness, even if somehow we're to understand that in the absence of evidence, that indeed the delegate was deeply familiar with the ATAGI guidelines, he'd read them, he'd considered them, and so forth. And it was those ATAGI, in other words, expert guidelines that were providing the foundation for his positive finding, it would involve a clear misunderstanding of the effect of those guidelines, which is that the recommendation is made of the grant of an exemption if the COVID-19 infection was within the past 6 months. Now, in a sense, all of that probably goes by the by, because it's simply not the basis upon which this delegate made their decision anyway. There's no evidence for that. Instead, we just have a bald positive finding of fact for which no evidence was provided, and which was contradicted by the only evidence that was before the delegate, that coming from Mr. Djokovic, and ultimately the eminent physicians that I've referred to on a couple of occasions. Your Honour, as for authority, I don't take this to be an issue. I'll just mention it. I won't take Your Honour to it, but ample full court, federal court authority for the proposition that even where policy guidance is not a mandatory relevant consideration, that where a decision maker does choose to rely on such policy guidance but gets it seriously wrong, that can involve jurisdictional error. The most relevant case, Your Honour, is the decision of the full court in a case called Gray, which is a migration case. It's tab 19 of the materials. The relevant quote is at page 208 of the judgment. I'll just read it out because it's very short. The full court says, if a decision maker not bound to apply policy purports to apply it as a proper basis for disposing of the case in hand, but misconstrues or misunderstands it, so that what is applied is not the policy but something else, then there may be reviewable error. So that completes, Your Honour, in a lot longer period of time than I might have originally expected, our analysis of grounds 1C and 1D in terms of why the delegate erred in purporting to form a state of satisfaction, which is what point 7 of the decision record concerns, that indeed Mr. Djokovic does indeed pose a risk to the safety or health and safety of the Australian community or a segment thereof. Can I much more briefly now deal with grounds 2A and 2B? They concern the second and distinct discretionary phase. Can I locate again where that comes up in the decision record? It comes up in a different point of the document. So we've been focused so far on point 7. What I want to invite you on now is to turn the page. So we're now looking at Bannister number 1, page 47. Yeah. See that there's point 8. And performing a similar function to which point set out with respect to the ground analysis. In point 8, the delegates invited to provide a summary of the reasons that Mr. Djokovic gave for why the visa should not be cancelled. So the words should not be cancelled are properly understood here, as now we've moved past the question of does the ground exist, and now we're in that part of the document that deals with whether the discretion should be exercised, assuming the ground exists. In other words, assuming that it's open to the delegate to be satisfied that Mr. Djokovic does pose a risk to the health of the Australian community. And there's a number of propositions reflecting points that Mr. Djokovic made. I'll come to the transcript in a moment. The first and important point I want to make about this part of the form is this. In point 9, it says delegates' assessment of the reasons the visa should not be cancelled. And what one sees is a pre-printed set of boxes that silos or is apt to silo the approach that the delegate takes to the task of considering the exercise of the discretion. So the first box with the pre-printed text is purpose of travel to and stay in Australia. And in substance, the delegate, when considering that question, made a favourable finding. Says purpose was it was a compelling need, indeed, for Mr. Djokovic to travel to Australia to participate in the Australian Open. The second box with the pre-printed text says extent of compliance with visa conditions. And again, a favourable finding is made. Mr. Djokovic has a compliant travel history with no evidence of non-compliance with visa conditions. Then we get to the third pre-printed box, the degree of hardship which may be caused to the visa holder, their family members, and so forth. And the delegate generously acknowledges that the cancellation decision would, quote, likely result in a reasonable level of inconvenience to Mr. Djokovic. Then we get to the next page. The pre-printed box is now client circumstances in which ground for cancellation arose, and importantly, brackets, whether there were any extenuating circumstances beyond the visa holder's control that led to the grounds existing. That's important. I'll come back to that in a minute. Ground 2B, Your Honour, is essentially a complaint that the delegate, and it's a simple point. I don't need to go much beyond what I've said in writing. the delegate, bizarrely, concluded, only addressed here whether there were extending circumstances beyond Mr. Djokovic's control, said that there weren't because whatever he got from Tennis Australia reflected material that he gave Tennis Australia, therefore says none of this is beyond his control, but therefore, bizarrely, says therefore the delegate applies significant weight in favour of visa cancellation. And as we've said in writing supported by High Court authority, the absence of extenuating circumstances can rationally only be neutral. It cannot provide positive support for the exercise of an adverse power, which here was cancellation. That's ground 2B. I need to say no more about it. It's extremely simple. The next box is visa holders' behaviour in relation to the department. And there's a favourable finding made. He's been cooperative throughout the process, implicitly accepting that he'd been honest and cooperative in his interview with the delegate. Then finally, we get to the box which would have been the box for the delegate to deal with the representations that Mr. Djokovic did make, but the delegate didn't do so. Why? Because this box is entitled Other Relevant Reasons. And it would be here in the form, Your Honour, where if Mr. Djokovic had presented evidence and submissions saying, in effect, why, even if the ground exists, the visa should not be cancelled, that the delegate would have to deal with that. Recall, as I said at the start, Your Honour, and as is common cause between the parties, the whole point of the 119 notice and 1191 paragraph B, Roman 2 in particular, is to give the visa holder the opportunity to explain that even if the ground exists, why nevertheless the discretion should not be exercised to cancel. And it would be absurd if such evidence and submissions are indeed made, but then they're not considered before the decision is made. But the short point, Your Honour, here is that Mr. Djokovic quite clearly, and given the time, I won't be as laborious going through the transcript as I was otherwise inclined to be, but quite clearly, repeatedly was saying, you should not cancel my visa, A, because I got the medical exemption from the panel, not the mere fact of having got it, but the content of it, what it signified, representing the expression of ATAGI guidelines. But moreover, and what I wanted to emphasise is, repeatedly Mr. Djokovic referred during the interview with the delegate to the fact that he had received the assessment document from the federal government. Recall, Your Honour, that was the document that came from the federal government that upon receipt of the exemption certificate from Tennis Australia, the federal government said your declaration's been assessed and your responses indicate you meet the requirements. And what Mr. Djokovic was repeatedly saying, we can provide a note later with transcript references, I'm conscious of the time, but numerous times throughout the transcript, Mr. Djokovic is saying, in substance, I made the declaration and then I got back from Home Affairs a document indicating I had been assessed as meeting the requirements. So in substance, what Mr. Djokovic was saying was, please do not cancel my visa, do not exercise a discretion to do so in circumstance where everything that I've been led to believe from Tennis Australia, from the product of the independent medical panel, but moreover critically for present purposes from the federal government itself, has told me I'm in the clear. And so even if, in other words, it was open to the delegate, contra all of the arguments I've made so far, to conclude rationally, which it was not on the evidence before the delegate, that Mr. Djokovic posed a risk to the health of the Australian community, or that his recent infection was not a medical contraindication of vaccinations that plainly was. Even if the ground existed, in other words, Mr. Djokovic was saying, given everything I've been told by everyone, please don't, in the particular circumstances of my case, when I'm here for a limited purpose to compete in an elite tournament, and I'm utterly confused as to why I'm in this situation, and no one told me anything about it, please don't cancel my visa. Please don't exercise that discretionary power. Nowhere does the delegate, in the reasons that are given, engage at all with that substantial and understandable submission and appeal and plea that was repeatedly being made by Mr. Djokovic. But the part of the form where that would have to be contained, if it had been considered, is this one, because it's other relevant reasons, and it's simply not discussed. Instead, the delegate confines himself to noting summarily a set of legal consequences that Your Honour should understand, meaning that if this cancellation decision is not disturbed, just so Your Honour completely understands the situation, he will be subject to a bar under 48 for applying for certain kinds of visas, but moreover, by operation of certain provisions in Schedule 4 to the migration regulations, will be unable to get any visa to come back to Australia for a 3-year period.
Yes, I do understand the force of that.
All right.
That is set out in the notice that was given to the applicant.
Yes, and so Mr. Djokovic is essentially saying, pleading to the delegate, in the circumstances, given what I've been told, don't do it. But it falls on deaf ears. It's not discussed. It's not evaluated in any active intellectual way. The final part of my submissions, Your Honour, concerns procedural fairness and unreasonableness. I think I can do it within about, particularly in light of the discussion that Your Honour and I have had in the running about those matters, in about 20 or so minutes. Would Your Honour like me to proceed on that?
Mr. Tran, is that convenient to you?
Yes, it is, Your Honour. Thank you.
Thank you. Well, Mr. Wood, if you're content to continue, I would be grateful if that can be achieved within the time you've indicated. The parties have set out in detail their positions about these grounds.
Thank you. And largely, I think what I can usefully do, given what we've already said about legal principles, and both in writing and to some extent orally today, largely what I want to do is take Your Honour through the bits of the transcript when you read it together with the affidavit of Mr. Djokovic that I wanted to bring to Your Honour's attention. At the outset, and I think I understand that Your Honour knows this, but just for confirmation, Mr. Djokovic's affidavit records at paragraph 18, and of course there's been no cross-examination, no attempt to contradict anything that Mr. Djokovic has said about his experiences at Melbourne Airport. What he says at paragraph 18 in the final sentence was that the voice recorder, which is what has been the basis upon which the transcript has been produced, was used throughout the night on occasions when I was being formally interviewed by the delegate, but not during every conversation I had with him or other Australian Border Force officers. So to understand what happened as the hours transpired, one has to...
I've read that evidence.
Thank you. Can I take Your Honour through the bits that I think are highly significant to the unfairness/unreasonableness complaints? Can I start with the transcript, Your Honour? And I'm doing this chronologically, but picking out the high points. Can I take Your Honour to page 11 of the transcript?
Yes.
Line 49. Mr. Djokovic says, and this is at about 3:55.
Yes, I've read that.
Yeah, so that runs from line 49 through to line 5 on page 12. I would encourage you to read that. On the same page...
Can you work from an assumption, please, Mr. Wood, that I have examined this in its entirety, but that isn't to suggest that I won't be assisted by you reminding me of the particular passages upon which you would have me focus.
Yes, that's all I'll do then, Your Honour, and I won't read it out given the time. So I would invite Your Honour to highlight, if you like. We're inviting Your Honour to read carefully. Page 11, line 49, through to page 12, line 5.
Yes.
Page 12, line 17, through to line 31.
Yes.
Then if we jump forward in time to page 17, line 1 through to line 15.
Yes.
Then I would take Your Honour to page 18. I would invite Your Honour to look at lines 1 through to line 6, as well as lines 17 through to line 21.
Yes.
Then I would take Your Honour to page 20. I would invite Your Honour to look at lines 47 through to the end of that page, and all of the way through to line 23 on page 21. Sorry, Mr. Hartley reminds me, I probably also ought to have identified to Your Honour on page 20, have a look at lines 25 through to 33.
Yeah, yes, which I have.
Thank you. Then, if we then move to page 22, This for the sake of those listening, we're now at 5:20 a.m. in the morning. So at page 22, have a look at particularly lines 28 through to, on page 23, line 9. And it's that particular part for note where the delegate indicated that he was going to be finishing his shift soon and the case was going to be handed over to another team. Now, that didn't happen, but what also didn't happen was the original agreement to allow Mr. Djokovic until 8:30 was not adhered to. So that's a bit of interesting context. Then it's at this point, so that exchange finishes at 5:22 a.m. You can see that at line 14 of page 23. It's at that point in time, to understand the matter chronologically, that one has to now go back to Mr. Djokovic's own affidavit, because now the tape's off. And if we look at paragraph 23 of Mr. Djokovic's affidavit, read paragraph 23 and 24 of Mr. Djokovic's affidavit in their entirety, the substance of which was, while the tape recorder is off, initially approached by two of the delegate's superior officers, given the peculiar advice that it was somehow in his interests not to speak to his lawyers at Tennis Australia and so forth, and that, it was better for him if they just made a decision. And then paragraph 24 concerns the subject of him being, Mr. Djokovic being woken up by the delegate and one of his superiors, presenting to him that it was, quote, better for me if the interview was done right away. And again, consistent with the proposition, putting the pressure on him to just subject himself to the decision being made rather than obtain the support and the assistance of those who might otherwise have advised him before a decision was made. So that's 23 and 24, which are off record. Then we come back to the transcript. And we're back on page 23 of the transcript. And so now it's 6:07 a.m. And I would invite Your Honour to look at lines 32 to 37 in particular. That's the exchange I think that Your Honour pointed out to me earlier. And that is effectively where it ends. The decision is made shortly thereafter. What clearly emerges from all of that, and what I've really discussed with Your Honour, is that it was abundantly clear throughout that whole process that Mr. Djokovic wanted more time, at least until 8:30, to speak with his advisors, his agent, Tennis Australia, to understand what was going on, to see if there was anything with the assistance of those persons and bodies that might be said in his interests to put against the suggestion that his visa was going to be cancelled. Point 2, that was initially acceded to, and it was agreed that he would be given until at least 8:30. Then, point 3, that agreement was reneged upon. The only basis upon which that 180-degree turn was adopted by the officers, as evidenced in the material, was the entirely spurious suggestion that somehow it was in Mr. Djokovic's interests if they just made a decision and he didn't talk to anyone who might otherwise support him and assist him to make submissions against why they shouldn't cancel his visa, and perhaps the suggestion of the practical concern of the delegate's shift being about to end, which could possibly provide a reasonable basis to make the decision when it was made. Very briefly then, Your Honour, as to law, we've run this point obviously in two different ways, fairness and reasonableness. They're distinct concepts, obviously, although they can cross over in their application. As to fairness, all I wanted to say, Your Honour, is briefly, this is the one point of legal dispute between the parties that I adverted to at the start of my submissions. If I can invite Your Honour to look at the Act, section 124, sub 1, paragraph A. Section 124 is headed.
I am sorry. Reach that point in the case. 124.
Yep. So section 124 has the heading, when decision about visa cancellation may be made. That's part of the partial code of the Natural Justice Hearing Rule.
Yes.
And it says that the Minister may cancel a visa at any time after notice is given under 119 and after whichever one of the following happens first. Now, what's emerged is that Mr. Tran, Ms. Wooden and our team are in agreement, having regard to legal principles, that here B didn't occur, and C is inapplicable. C is inapplicable because this was not a time-bound duration process. That's because the delegate exercised power under 121 to invite the response to be given at an interview, which is not a period of time that is bound by a period. So the only issue between the parties, Your Honour, is whether or not by the time that the decision was made, which I think was at 7:29.
Yes, notified.
7:29 notified to Mr. Djokovic at 7:42. I think I made an error about that earlier. So a decision was made at 7:29. The question is, under 124 of the Act, at 7:29, is it the case that the holder had, quote, responded to the notice? And the dispute between Mr. Tran and myself is essentially this. Mr. Tran submits, as he did last night in writing, that respond there can't mean, in effect, complete response. It just means a response. And we say that is obviously not so, and indeed, were it so, it would generate perverse consequences, because a visa holder might be, in effect, partway through saying what they want to say about why the ground doesn't exist and why the discretion shouldn't be exercised if the ground does exist. And the minister might say, I've heard enough, you have responded in part, I'm now going to make a decision. Obviously absurd. The way that Mr. Tran tries to ameliorate that perverse consequence of his interpretation is to say, it's okay because principles of legal reasonableness kick in. And of course, the minister couldn't, or the delegate couldn't, without contravening, would have to adhere to the principles of reasonableness in deciding when the minister thought that the applicant had responded, whether he'd heard enough. The problem with that is it conflates very different concepts of fairness and reasonableness. Mr. Tran's submissions are at pains to point out the very broad decisional freedom that he adverts to the cases speak of when it comes to reasonableness and the wide discretion that decision makers have and so forth. And so what he's really, the effect of his submission is really this, that the minister has a wide discretion, understood in that reasonableness sense, as to how long they're going to listen to a visa holder. What that does is it transforms a right to due process, a right to fairness to make a response, into a discretionary power of the minister to how much a response someone is in fact going to get. We say that's wrong. The right way to understand 1241A is that the holder will have responded in this circumstance where the response was to be given at an interview, because that was the mode selected under 1211B of the Act, when in effect during the interview the visa holder has indicated that they have said all they wish to have to say. And the analysis is not assisted by extreme or distorting possibilities. Mr. Tran says, oh, well, couldn't the visa holder just filibuster, potentially forever? Well, that's the very kind of distorting possibility. Can
I ask a question on the facts of this case? Wherever the parties might find themselves in some dispute about whether, in a particular case, an interviewee was filibustering or just being intransigent, but effectively putting a stake in the ground and maintaining I haven't finished and you're not going to be able to do anything until I tell you I have, or perhaps in a different situation where a delegate acting quite reasonably says, look, is there anything further you want to say, or have I understood your submissions? In the objective facts of this case, the situation in which these grounds are being pressed are those disclosed by the transcript, namely that it seems uncontroversial this interviewee wanted until 8:30.
And he expressly identified he wanted to speak to particular people and organisation before he could meaningfully respond, because he was essentially saying, I have no idea how this could have come to pass given the advice I received from Tennis Australia, the state government and the Commonwealth government. And to meaningfully respond to what you're putting to me, I need to speak to those people. And so Your Honour is absolutely right to ignore distorting possibilities and focus on the facts of this case. And ultimately, it's a question of characterisation. Is it or is it not the case in the circumstances that are presented here and the evidence before the court that Mr. Djokovic had responded And the answer to that is no. He had started to respond. He wanted to say more, but in order to say more, he needed to speak to certain people and certain organisations, and that opportunity was denied him. And therefore, it follows that there has been a breach of 124 sub 1 paragraph A, which is part of the partial code of the Natural Justice Hearing Rule, and that would be a sufficient basis upon which my client could succeed. In the interests of time, I'll rely on what I've said in writing about WZARH type analysis invoking general law concepts of fairness that survive the partial codification in the Act, and I'll move just very briefly to speak about unreasonableness. I really have covered this before in the discussion that I had with Your Honour about Lee, and this being a circumstance where there was simply no intelligible basis other than ones that can't be justified, the convenience of the shift ending of the delegate or the manifestly perverse advice given to Mr Djokovic that was in his interests for a decision to be made before he spoke to his advisors. There was no reason, no intelligible reason not to allow him that more time. And so this case is one of the starkest I've ever seen for the application of the principle articulated by the High Court in Lee. And for that reason, it would readily be impugned on the basis that, irrespective of questions of fairness, the conduct of the delegate and the officers was unreasonable. They are my substantive submissions, Your Honour. I just want to say two things which I can do in about 1 minute. First of all, on the question of relief, if Your Honour is persuaded there's been one or more jurisdictional errors, Your Honour would quash the decision. Your Honour would not remit the matter because there's no duty that to which an order of mandamus would attach. Your Honour.
Mr Wood, during the recent brief adjournment, I took occasion to confirm that the audio statement which we all heard in this hearing is a statement which relates to the live streaming which has been conducted via a separate channel somewhere else, and it's something that we can disregard.
Thank you, Your Honour. So I'll continue my brief closing point. So Your Honour would quash, Your Honour would not remit. Your Honour ought to, it may not be strictly necessary, but we say Your Honour ought to make an order requiring the release of the applicant from immigration detention. It may not be strictly necessary because that would be legally obligatory on the officers to release him anyway, because as soon as the cancellation decision has been quashed, the visa jumps up like a jack in the box and there'd be no basis upon which he could be detained. But the federal court in recent history has considered it appropriate.
I've read the decision.
Thank you. Finally, Your Honour, 2 points. First of all, we maintain our submission that it's open to Your Honour to grant. Your Honour, obviously, as a Chapter 3 court, must give reasons for your decision. Your Honour does not need to give reasons for the decision at the same time. That's clearly so. And there are ample cases, and we've cited some, where considerations of urgency of various kinds have caused courts to give orders before reasons. If Your Honour, I'm submitting, is not in a position to give reasons at a time which would enable my client practically to compete at the tournament were he to be successful, we would in that circumstance urge Your Honour to make an order and for reasons to come later. Finally, Your Honour, with respect to the interlocutory injunction, it may be to some extent overtaken by events in that last night Your Honour ordered that the Commonwealth ensure that Mr Djokovic be present with us while this hearing continues, and I think Your Honour has now indicated until judgment. To the extent necessary, I would rely on all of the submissions I've made today and all of the submissions that we've now made in writing in support of the proposition that Mr Djokovic plainly has a strong prima facie case for relief. The balance of convenience heavily weighs in favour of the grant of an interlocutory injunction.
Mr Wood, can I just say this? Mr Tran has made submissions representing a model litigant, and at least on Thursday was clear that at that point, subject to further qualifications, which he was equally clear to make then about the future, that deportation was off the table at that point. I'm not suggesting that position obtains in an unqualified way into the future. What I am suggesting is rather this, if you'd bear with me. If one accepts the submission respecting the delivery of a judgment, which could be the subject of an appeal, as distinct from the provision of reasons for the judgment and orders, then the type of interlocutory relief to which yourself and Mr. Tran may wish to turn your attention may be time limited, as it were, for a period of 48 hours after the expiry of any available time for the lodging of an appeal. I haven't reflected fully on this, and it's one of the reasons I wanted to ask you and those assisting to exchange with Mr. Tran a draft minute which precisely mirrors what you consider to be given by way of judgment at a final hearing. I won't say anything more about that aspect of the matter and the nature of the injunction that should be given on a final hearing. But the only other issue, well, look, just while it's in my head, it would be the usual practice, and you'd both be content, I imagine, for any issue of cost to be dealt with on the papers in the usual way. You can make short submissions, and I'll do that in chambers. The other thing that I think far more important on the evidence of Mr. Djokovic, which seems to reflect the fact, working backwards, he provides a range of documents to the delegate, which I think in all material respects are copied, so there may be no problem there. The problem, which is a more immediate one, is the uncontradicted evidence that he has given his passport and does not have it. So I am concerned to decide this matter on a final basis, and I will be less than grateful if someone after the event says, oh, there are other things we're now thinking about. That clear?
Yes, Your Honour. We have prepared a draft minute of proposed order, but we'll reflect on what Your Honour just put to me.
Yeah, that's exactly why I raised it, because, you know, let's be honest, if we all stand back from these things with the degree of cooperation that is being shown in this case, if all parties make a valuable contribution to what they represent or submit represents an appropriate form of complete final order, albeit that you might disagree with one another, but you'll put together a composite document that embodies everything and provide it in Word format, then that's what I'm asking you to do. Now, Mr. Tran, it being nearly 1:30, I propose not to adjourn, at least not before 2:30, but having said those things, two matters. My present understanding is that you are content to proceed today, subject to instructions, which is a matter that you can inform me about now or later if you want. But I'm not going to bring the matter back until you've had at least an hour, unless you want some further time beyond that, say 3 o'clock. The other matter, which perhaps your junior Ms. Wooten can assist the court with via email to myself and counsel on the other side. If you have in contemplation taking the court to a series of documents in the evidence or a series of authorities, I'm not going to tie you down to how you want to frame your submissions, but if you would be assisted by me being informed in advance of things you would like to commence addressing, then I'd be very happy to know that, if that's something you want to do, and you don't have to do it.
Your Honour, can I propose this course? And of course, Your Honour will hear from Mr. Wood and Mr. Holdenson whether they have any submissions about this. What I would suggest, if Your Honour is minded to allow me to do it, is if I could speak for perhaps up to 30 minutes to get us to 2 p.m. The purpose of that is, I think, to make some comments about where I'm actually going and to highlight in my respectful submission what are some of the key issues for Your Honour. In
Of course.
of that, I will attempt to make some submissions about what some things might be non-issues, and I'll also highlight a few authorities. And then if you could take the adjournment at 2 o'clock, I think the utility of taking that half hour will help frame for your
That's a very helpful suggestion, and I see Mr. Holdenson and Mr. Wood assenting to that suggestion. I'm very grateful for it. Thank you. Please proceed.
Thank you, Your Honour. I'm going to start using this short 30 minutes by addressing paragraphs 3 and 4 of the reply submissions, and then charting for Your Honour how it is I propose to deal with ground 3, and then after the adjournment, I'll actually do that, deal with ground 3. If Your Honour brings up the reply submissions from very early this morning and goes to paragraph 3, and Your Honour will read there, and this is my gloss of it, but of course Your Honour can read it. It says there, my gloss, that the applicant was pressured during that transcript that Your Honour has read. Can I be crystal clear that Your Honour can rely on that submission and that evidence to find as a fact that the applicant felt pressured? Of course, I haven't sought to cross-examine the applicant. But can I make it crystal clear that what Your Honour can't do is find that any officer intended to pressure him? And Your Honour will appreciate the difference there. And Your Honour,
I do. Look. I will tell you immediately. If you understand that I have a very great desire to engage with counsel in a fairly Socratic way, so that you can remind me squarely when you say Your Honour's going down the wrong path, you need to listen, and this is something you might be assisted by. Now, the point you make, the distinction between any positive, affirmative desire to impose pressure is just something I can't make a finding about. You needn't worry about that. But as to the evidence of a subjective belief, there is that evidence and you accept that.
Yes, thank you.
That's good. Thank you.
I'm grateful that Your Honour has expressed Your Honour in the way that Your Honour has. So I don't need to address paragraph 3 anymore. But it was important for me to start with that, because if Mr. Wood or Your Honour indeed had a different view, then that would have repercussions for the ongoing conduct of the case. So
yes, it would. It would. And I should, of course, I mean, I'll wait to hear what anything that Mr. Wood might want to say in reply, but perhaps a way. What can I just say this without encroaching on your 30 minutes? I tried to tease out with Mr. Wood, and I think we reached common ground that whether it be unfairness or legal unreasonableness, it's a fact-intensive inquiry, and you can't take the facts and circumstances of any other decision as dictating the result in this. It is fundamentally a matter for me to decide whether, in all of the circumstances of this case, and just to bookend it as quickly as I can, in shorthand, 11:30 to 7:42, that's what I'm examining, and I would be most reluctant on the available evidence to impugn the conduct of a decision maker for an actual intention to pressure on the basis of the evidence which is here. Now, that may not be sufficient for you. It doesn't kill the point. It just means that ingredient, perhaps the better way to think about it is, as I said, I think on Thursday, care is needed not to overreach or overstate. Now, whatever the facts of the circumstances were, the particular delegate was darting in and out of the room, which was being video recorded, and a fair inference, and tell me if this is not available, was that he was, in a sense, going out, consulting, getting further guidance, coming back in, dealing with another issue and so forth. But whatever happened between interview number 1 and interviewer number 2, there is evidence about how Mr. Djokovic felt.
Yes, I accept all of that.
Thank you.
I accept all of that. Thank you. So if I could then address paragraph 4, Your Honour, and Your Honour can read that to yourself. Essentially, it actually repeats something that Mr. Wood said orally this morning, that we did not respond to the submission that there is no law requiring a person to be vaccinated to enter Australia. or to have an exemption. Your Honour?
Yeah. Yes.
Now, we didn't respond to that because in our submission it's not relevant to any of the grounds. None of the grounds alleges that it was not open to the delegate to have been satisfied of section 1161E in the circumstances of this case. What the grounds are in my submission, particularly with ground 1C, all the Atagi material, is not illogicality or unreasonableness in the ultimate decision, but illogicality in a step of the reasoning adopted by the delegate in reaching the final decision. That doesn't mean that we
A step along the way.
Indeed. That's very clear actually from paragraphs 27 to 29 of the terms of the application, which Your Honour has given leave for them to file. I just want to make that clear because it makes good my submission that in the end, actually, whether or not there is a law requiring a person to be vaccinated to enter Australia or to have an exemption is beside the point. And to make this additionally clear, I don't say this to say that ground 1C fails at the threshold or anything like that. Of course, I'm going to have to deal with ground 1C as it's been put by Mr. Wood. But I did want to make that clear because Mr. Wood has said it orally and said it in writing, and therefore I take it the applicant considers that to be important to their case, and we say it's not important given the way that the grounds have been framed. But can I also say this, Your Honour? There is at least one provision that exists on the statute books that permits the executive, the Commonwealth Executive, to control who may enter and remain in Australia, and that is, of course, section 1161EI itself, the very provision exercised here. That provision does not present a high bar. Can I just go to two cases only in this half hour, Your Honour, because then I can clear this away and not have to deal with it this afternoon at all.
Thank you, that would be useful. Just hang on a second. What's the first?
The first one is in the supplementary authorities that we provided this morning. I apologise to the court for the lateness of it. And
well, what you've said means that we'll have to deal with it more efficiently in another way. Tell me the name of the case, citation, and the paragraph.
Perfect. So it's Minister and ERY 19, Medium Neutral Citation 2021 FCAFC 133. Your Honour, over the adjournment, we'll see that's tab 8 of our additional authorities.
Have they been delivered in hard copy, do you know?
If they haven't, they will be in the next hour, Your Honour. And so
that's all I need.
It's even more serendipitous.
Paragraph again.
The paragraph references will be 81 and 82. It's serendipitous that Your Honour has given me the indulgence of this half hour. I can tell Your Honour succinctly what the propositions are there. Paragraph 81 emphasises that the word risk imputes notions of possibility. Paragraph 82 says that the word risk is sufficient to connote possibility in quite the same way as by the use of the word might. That was Justices Lee and Wheelahan of the full Federal Court.
Yes.
The second case, thankfully, is before Your Honour. This is in Part A of the existing authorities. It's Leota and Minister, tab 12, Medium Neutral Citation, 2020 FCA 1120.
Yes, paragraph.
Paragraph 15. Thank you, Your Honour.
Thank you very much.
And the point that I draw out of that, while everyone is turning it up...
Which I have.
Thank you, Your Honour. The point we draw out of that is Her Honour Justice Banks-Smith emphasises that the statute was amended in about 2014 and lowered the bar even further. So one doesn't even have to be a risk, one might present a risk.
Yes.
And
maybe,
again,
might be, clearly lowest threshold.
Indeed. And again, I repeat, there is no challenge to the actual ultimate decision, just very many and several challenges to the reasoning process, which I'm going to, of course, have to come to.
Sorry. Can I just step back from that again, because it may be something that I need to clarify in reply.
Yes.
I've already clarified with you that at the forefront this case is what we call a step along the way.
Yes.
Now, for others, the way in which a ground of unfairness or legal unreasonableness might be made out could occur at the simple level, one which is focused solely upon the process by which the decision is reached, that is, the steps along the way leading to the decision. The other way, as you've put it quite correctly, is that the legal unreasonableness could, or the unfairness could, flow from the fact of the decision itself. And as you're submitting, and I need to be clear, particularly from the applicant, you're submitting, do I understand you correctly, that you say that the applicant is not contending that the decision in and of itself is tainted by tainted by jurisdictional error, which is in the character of unfairness or legal unreasonableness. You say the decision itself is not being attacked on that ground.
Indeed, that is correct, Your Honour.
It's only a process-based challenge.
I think I'm sort of half in between, Your Honour. There are very many process-based challenges, and before I sign up at 2 p.m, I'll explain to you how I'm going to deal with those.
Yes.
There are certainly process-based challenges. There are also rationality and unreasonableness challenges.
That's why I ask you.
Go beyond process, but the point that I'm making is that those are still unreasonableness and illogicality grounds that challenge intermediate steps in the process of reasoning. They don't ultimately challenge, they do not actually allege that it was simply not open to be satisfied of 1(1)(c), 1(e)(i). The allegation is more nuanced. The allegation is, given the reasons that you've given, you couldn't be satisfied because some of those reasons were affected by illogicality and unreasoning.
Well, I just think you might need to reflect upon that. And if we need to travel a little over 2 p.m, don't worry about it at all. But the point is, depending upon how one undertakes the analysis, if there are, if you will, 5 elements within a process which leads to a decision, and you found for one reason or another, forget this case, just any case, you just found that the particular finding of fact or the particular reasoning was utterly irrational or unsupportable or illogical, then that would effectively destroy or undermine the ultimate decision. And I just, at first instance, may be assisted by submissions that separate that out in a way. I can understand why a person might want to isolate these challenges and try to answer the individual challenges as a process of analysis, but is that potentially too granular approach in the sphere of unfairness or legal unreasonableness? I don't think I could say more about this stage, but if I feel a reservation, I think in fairness to you, I should make it clear.
I'm grateful, Your Honour.
Thank you.
I think this is most usefully explained. I don't propose to take Your Honour to it now, but I'll provide you on the citation.
Yes.
Justice Robertson's well-known judgment in SZ RKT at paragraphs 150 to 158, where His Honour draws a distinction between illogicality or irrationality in the final decision itself, or illogicality, irrationality in any of the intermediate findings. And the only reason why I emphasize it here is to, and this is going to have more significance in the submissions this afternoon, is to assist Your Honour, hopefully, to impose a structure about how to then analyse and fit in all the various submissions that Mr. Wood, on behalf of his client, has made this morning.
We might be able to fast track this, not now, but in the ultimate result, because I thought I've obviously got to go back and look at His Honour's reasoning, and it's a celebrated case which has been endorsed so many times that it doesn't matter. But the point, I thought, when you read the totality of the reasoning, His Honour was very careful to make some observations about the utility or appropriateness of quarantining the analysis in an overly rigid way, and that's a very general way of putting it, but I mentioned that for what it's worth.
I'm grateful, Your Honour. But so that's the additional thing I wanted to say in response to paragraph 4. Can I then foreshadow how it is that I propose to at least commence after the adjournment? And I will be commencing directly with ground 3, because collection of ground 3A and 3B.
Very good.
Because Your Honour will appreciate that those grounds aren't about whether or not it was correct in any lay or legal sense for the delegate to have applied section 1161EI to cancel the visa. Those grounds really do strike at the process by which the delegate applied that provision. And of course, a decision maker has to comply with legal process.
Yes.
And Your Honour had raised with Mr. Wood, and this is my gloss, leaving aside the legal niceties, there are a set of facts here, and how should we assess and characterise these facts? The way that I will propose to deal with this after the luncheon adjournment is in this way, Your Honour. I will first explain that section 124 was complied with, in the sense that a response was given, and therefore section 124 did not impose a bar on a decision being made. Second, I'll then say that there was no denial of procedural fairness for 2 reasons. The first reason is that in my submission, one does not go to the general common law principles of procedural fairness, because the decision to make the interview commence earlier is a matter that's dealt with by the statutory code. So if there has been compliance with, for example, section 124 and all the other provisions around it, then that is a matter that is dealt with by the exhaustive statement of natural justice in that subdivision. And so one does not go to general common law procedural fairness.
Yeah, can I replay that so I try and persuade you I've understood it? All the structure throughout the Act, when it deals with exhaustive statements of the natural justice hearing rule, provides in short compass that the provisions in whatever division or part we are concerned to look at are expressed to be an exhaustive statement of the matters with which it deals, or they deal.
Yes.
And you're saying to me, properly understood in the circumstances of this case, the relevant provisions were engaged, so you don't step outside into common law procedural fairness.
Correct. That's going to be my primary submission there. And then I'll say something a little bit more about even applying general common law procedural fairness as a secondary
Yes,
argument.
of course. Yes, yes.
But then after that, I'm going to deal with legal unreasonableness. And I wanted to alert Your Honour that this is how I'm going to approach it, because in dealing first with 124 and then second with the statutory code of procedural fairness, I appreciate that it's going to look like I am hiding behind legal principles when really it's the facts that Your Honour wants to get to grips with. I wanted to assure Your Honour that I will get to the facts when I get to legal unreasonableness. But of course,
Mr. Tran, again, just so that you and I can speak candidly about this, you understand that it is, and tell me if you have another view, it's an inherent aspect of the nature of a final hearing that because the plaintiff or the applicant goes first, they have the opportunity to put all the colour on the canvas, and that in a sense becomes a platform or an opportunity for the court to interrogate those ideas as fully as it can, so as to give, in the first case or instance, an opportunity to counsel for the applicant, an opportunity to say, Your Honour's misunderstood me. What we're really saying is X or Y or Z, so that I can have, at the time of that engagement, some reflection upon whether I've understood the facts or whether the canvas needs to bear some different hue or colour. The second aspect, of course, which is, I think, the important part for you and I now, is while I do that in that part of the applicant's case, a very important related part of it is the collateral objective of giving a respondent forewarning of the sorts of issues that are being ventilated, so that in turn you say, well, forewarned is forearmed, and Your Honour might have had an indicative view about these things or tried to interrogate those ideas, but we want to say some things about that too. And you say, I should not misunderstand the submissions from the Minister as being carefully rehearsed, sophisticated statements confined to legal principles, but you say you want to emphasise matters of fact which justify the dismissal of the proceeding for which the Minister contends.
Yes, Your Honour. And the only thing I'd add, of course, is it's been, I say this gratefully to Mr. Holdenson and Mr. Wood and to Your Honour, that given the urgency with which this proceeding has been brought on, of course, it's also been very useful to hear how they articulate their case this morning, because, of course, the proceeding's only been on foot since about Thursday or Friday. And so that is how I propose to proceed, and then we'll get on to some of the other substantive grounds after that. But I do propose to proceed in that way after the luncheon adjournment, if the court pleases, to focus on not the grounds that go to whether or not, for various reasons, Section 1161EI could lawfully be applied to the applicant, but really to focus on what, in my respectful submission, are some of the things that, at least as the applicant puts it this morning, do at least raise real questions I'm going to have to persuade Your Honour on about the process which the delegate followed. And so that's what I will do after the adjournment, if the court pleases, in the manner that I have described.
Mr. Tran, have you nearly said everything you want to say at this point?
I have, Your Honour. If I can foreshadow just a couple of cases which I think it might be useful for Your Honour to look at. One is the Taylor decision, which is volume 253 of the Commonwealth Law Reports, starting at page 531, which will be behind tab 16 of the additional authorities that will be delivered to Your Honour's chambers over the adjournment. Yes. I'll be relying on that for what the High Court says about whether and when one can read words into a statute.
Yes.
It's going to be relevant to section 124. I will ask Your Honour to refresh Your Honour's memory, because Your Honour will be very familiar with them. The case of CRY 16, 2017 FCAFC 210, which will be behind tab 6 of the authorities that are delivered, and the High Court's decision in plaintiff M174, which is volume 264 of the Commonwealth Law Reports at page 217, which will be behind tab 13 of the authorities. Those are really just for the proposition that there is actually, of course, a close connection between procedural fairness and unreasonableness, such that, and I can make this concession, Your Honour, such that even if I'm right, and I will persuade Your Honour that I am right and that Ms. Wooden is right, that section 124 was complied with and the statutory code of procedural fairness was complied with, I accept that does not get us off the hook in defending the unreasonableness ground. There is a close connection such that if Your Honour were concerned that the applicant was denied procedural fairness in the exercise of the Commonwealth's right to attempt to apply section 1161E, well then that is something that would inform Your Honour's assessment of unreasonableness. So those cases help to bear that out, and with respect, I think, will be things I actually have to persuade Your Honour against my case. So those authorities may be of assistance to Your Honour and to Mr. Holdenson and Mr. Wood. Can I identify just a couple of other authorities for Your Honour? One is the McHugh decision, 2021 FCAFC 152, which will be behind tab 5 of the authorities. Your Honour, that's a very long judgment, but it's a very simple point that I'm going to be getting out of it, which is there's no doctrine of estoppel against, or estoppel restraining the exercise of statutory powers. That's actually the only proposition I get out of it, so it's a very long judgment. And a related judgment.
Sorry, just while I try to digest that observation, it's a somewhat sophisticated proposition. that this will involve, I would hope from you, some engagement with the idea that I took up with Mr. Wood on Thursday last week when I sought to check the direction in which I was sure he wasn't going, but to have him help me understand what he was trying to actually help me understand. And the way in which he put it effectively is we're not concerned here with any doctrine of legitimate expectation. And he said that's absolutely right. That has the nail in that coffin has been rusting there for some decades, but more precisely, he went on to qualify it by saying, and he's clearly cast and framed the case in this way in part, there's a qualification in the authority to which he referred and about which I'll be reminded, but keys into what you're now saying, that notwithstanding the rejection of any such doctrine, that doesn't foreclose some idea that if a representation was made, that could be relied upon. The idea of estoppel is it's a wriggly fish, Mr. Tran.
No, it is, Your Honour. And that's why, again, I'm grateful for Your Honour's indulgence in permitting me this 30 minutes. So I can at least put a few markers in the sand, which are...
No, helpful. I'm very, very, very grateful. Next.
And then I was going to say Lamb's case, 214 CLR 1, which will be behind tab 15, but Your Honour is, of course, very familiar with precisely what I was going to take Your Honour to Lamb for, substantive and procedural legitimate expectations. But that is going to be one of the cases that I was proposing to go to. And then finally, I think it will be useful for Your Honour to consider two cases. Both of them are going to be losses of mine. So I'll be revisiting happy memories. The first one is going to be Environment Centre Northern Territory Inc. 2021 FCA 1635. That is potentially a useful case for Your Honour to consider, because that was a case where Justice Griffiths found of the Federal Court that an exercise of statutory power was unreasonable in circumstances where a representation had been made about one date and then the exercise of power had been exercised on a different date. That, at least as I've described it, might sound a little bit similar to what we're getting at. And what I'll attempt to do this afternoon is explain how that's distinguishable. So that will be in the folder of authorities as well. No parties alerted Your Honour to it, but I thought overnight that's actually somewhat close. And so
I said to you last week, inevitably, it's the kind of case where parties are going to bring to mind some late in the piece additional authorities, but you've said enough to indicate to me and through me to the instructors the immediate need for somebody to get this material to me in chambers.
Yes, and then the last case I'll alert Your Honour to is Parata 2021 FCAFC 46. And the reason for that is this. Your Honour will recall this morning some exchanges with Mr. Wood about the notice of intention to consider cancellation. And Mr. Wood correctly brought to your attention that a necessary condition for the exercise of power under 116 is that you have a notice which is valid, a notice which complies with the requirements of section 119. If Your Honour recalls that, that's ground 1A in particular. In my respectful submission, what the applicant's submissions have not grappled with yet is when it is that a notice of intention to consider cancellation is valid. So I, of course, accept, and Ms. Wooden accepts, that is necessary for us to persuade Your Honour that it's valid. If Your Honour finds it's invalid, then 119 hasn't been complied with, 116 isn't available. But in our submission, there's going to be two cases that will be very important for Your Honour's consideration on that very question. Is it actually valid or not? Is what we describe as a typographical error, which Mr. Wood described in more florid but perhaps accurate terms this morning, is something that takes beyond something that complies with 119. So the first one, as I said, is the Parata case, which is the full court. The second one is the Udin case, UDDIN, which is in the existing authorities, which is tab 22. So I'll take Your Honour to those this afternoon, and Your Honour will appreciate, I will submit that those authorities will show that this notice was valid despite the mistake which Mr. Wood took Your Honour to. So that's what I'll do this afternoon, and I'm grateful to Your Honour for allowing me to identify some of those matters.
Yes, Mr. Tran, just before we adjourn, one of the issues that I sought to draw to the party's attention in relation to the cancellation notice in each of Part A, Part B and Part C is that the delegate seems unambiguously to have confined the ground for his conclusion to paragraph 116E Roman 1, and conversely, or by extension, not to anything arising under section 1161D or regulation 243 or anything else. And there is that final box to be ticked by a delegate which uses the broad catch-all, if you will, of other. Now, having regard to the manner in which the delegates expressed his reasoning, I would be assisted if you could deal with those parts of that notice at some point.
If I could do that right now, Your Honour, I can confirm for Your Honour that our position is that the only ground that the delegate relied on is indeed section 116 1E Roman 1. And I would even go further. The delegate only relied upon the health aspect of that, because Your Honour will see, and Your Honour is now very familiar with the provision, that it says health, safety, or public order.
Yes, that's helpful. I've got it.
The delegate only wanted to rely upon the health limb of that.
All right. Mr. Tran, thank you for that outline, and Ms. Wooten, I will adjourn until 3:15. Adjourn the court.
The Federal Circuit and Family Court of Australia stands temporarily adjourned until 3:15 p.m. Affairs for hearing.
Yes, Mr. Tran.
Your Honour, three things. First, may I convey Ms. Wooden's apologies. She's otherwise detained, which means no disrespect by it. That's the first thing. The second thing is, can I note that the injunction is to expire at 4 p.m. I have instructions to consent to an extension of that to at least 4:30. But if Your Honour's minded to extend it a bit longer, so be it.
I am. 8 p.m.
Thank you, Your Honour. The third thing is, if I may respectfully request an additional period of time, can I say that it will not prejudice the hearing for this matter tonight?
I understand, Mr. Tran. Can I assist you or the applicant in any way before you have the further time you want?
No, I don't think so, Your Honour. I just require
Adjourn the court.
The Federal Circuit and Family Court of Australia stands temporarily adjourned.
This conference is no longer being recorded.
Really?
Your Honour, we obviously agree fundamentally to relief, including quashing and
Sorry,
release.
can you just take me through the paragraphs, because I need you to understand, each of you, that it is my proposed intention to read this minute once I understand your position. If there are particular paragraphs where the text needs to be improved, can you draw my attention to them?
Just bear with me, Your Honour. Your Honour, I'm sorry to be difficult. Can we have 5 minutes to get instructions?
I must say, Mr. Wood, I take the view the court has, for the last 5 days or thereabouts, bent over backwards to accommodate these parties in a variety of ways. And I had made arrangements to secure last night that your client would be with you today. Now, I've assumed that's occurred. Am I correct?
Yes.
So, Mr. Djokovic is there with you?
Yes.
Yes, Your Honour.
And is there any paragraph of this proposed consent minute which is the subject of any difficulty?
No, Your Honour.
Then in those circumstances, the court will order as follows. Paragraph 1. The decision of the delegate to cancel the applicant's temporary activity subclass 408 visa made on 6 January 2022 be quashed. 2. The respondent pay the applicant's cost bracket, including any reserved cost bracket, comma, as agreed or assessed. 3. The respondent is to take all necessary steps to cause, new line 3.1, the applicant to be released immediately and forthwith from immigration detention and, comma, without limitation thereto, comma, such release must occur by no later than 30 minutes after the making of this order, semicolon, and new line 3.2. The applicant's passport and all other personal effects to be returned to him as soon as reasonably practicable after the making of this order, period. New line. Caps notation. Cap A. The respondent concedes that the delegate's decision to proceed with the interview and decide to cancel that visa under Section 116 of the Migration Act 1958, open bracket, CTH, close bracket, was unreasonable in circumstances where, new line, open bracket, 1, the applicant was told at 5:20 a.m. on Thursday, 6 January 2022, that he could have until 8:30 a.m. to provide comments in response to a notice of intention to consider cancellation under Section 116 of the Act, semicolon, new line, bracket 2 bracket. The applicant's comments were then sought at about 6:14 a.m. Instead, semicolon, new line, bracket 3 bracket. The delegate's decision was made at 7:42 a.m. New line, bracket 4, close bracket. The applicant was thus denied until 8:30 a.m. to make comments, semicolon, open bracket 5. If the applicant had until 8:30 a.m., he could have consulted others and made submissions to the delegate about why his visa should not be cancelled. Is that the totality of your minute, gentlemen?
Yes, Your Honour, on behalf of the
I
respondent.
propose, subject to the parties' views, having regard to the text which you've agreed in, with particular reference to paragraph 3.1, such release must occur by no later than 30 minutes after the making of this order. I will add a further notation which you will prepare for the court and submit to me as soon as you can. This order was pronounced in open court at 5:16 p.m. on Monday, 10 January 2022. Mr. Wood, is there anything further?
No, Your Honour.
Your Honour, there are two things from me, if the court will hear from me, please.
Yes, please.
First, Your Honour, I've heard what Your Honour has said, and of course there will be compliance with your orders. That goes without saying.
I
But
agree.
to avoid any unintended discourtesy to Your Honour and court staff, I wouldn't want Your Honour and the court staff to hear this through any other means.
Yes.
I think I must inform Your Honour that I'm instructed that the Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs, not the Minister in this proceeding, will consider whether to exercise a personal power of cancellation under section 133C sub 3. Those are my instructions to inform the court to avoid that.
No, Mr. Tran, your candour is both entirely appropriate and necessary. It would be fair to say that I could have been something approaching incandescent if I discovered that for the first time in the later hours of this evening or the earlier hours of tomorrow. What I do require then in those circumstances is this: you must add notation C, counsel for the respondent, comma, Minister for Home Affairs. I'm sorry, Mr. Wood, you're being interrupted by someone and it's not helping me. I expect the applicant, as the party moving for relief in this proceeding, to undertake the primary responsibility for the preparation of this minute and its submission to me without delay, as I said before. Now, Mr. Wood, you of course understand that none of that was directed at you, but I do need this to happen. We have had too many systemic problems with the communication between the court. This order must be sent to me as soon as possible. Now, I was midway, Mr. Tran, in dictating the substantive text of notation C, which was to provide, in substance, counsel for the respondent, comma, the Minister for Home Affairs, comma, informed the court that despite the making of this order, comma, the Minister for, insert full name of other ministry, has reserved the question whether to exercise a personal power to cancel the applicant's visa pursuant to paragraph # of the Act. Have I got the substance of it, Mr. Tran?
The substance is correct, yes, Your Honour.
Well, can you make sure that you maintain close dialogue with Mr. Holdenson, Mr. Wood and his team, and accelerate the provision of a joint minute that you say embodies everything that has been agreed?
Yes, Your Honour. And then only one last thing only. I was discourteous in overlooking to announce in my time before lunch that Ms. Wooden was to address the court on grounds 2A and 2B. Of course, that's no longer necessary, but I should have announced that before, and I didn't.
Well, look, I would have thought at this point it would have been sufficient for you and Ms. Wooden to recognise that one of the first or second issues that I addressed with you today before I allowed any submissions to be made was to recognise the extraordinary diligence which has been demonstrated by counsel and their instructors. And that, of course, incorporated by reference Ms. Wooden, and I am particularly grateful for her contribution in the time she's been in the case. Now, having dealt with those niceties, there is a matter of some importance to me. As I am concerned, gentlemen, this proceeding is concluded and I am functus officio. there then arises a very real question of what might be seen more broadly as the administration of the interests of justice. If there is to be the exercise of personal power by some other minister following the applicant's release, pursuant to the personal power that you've given reference to, the first thing that occurs to me, having not received any notice of it, and I cannot complain about it because it hasn't arisen, is this. Part of the submissions in this case have included that the personal and professional reputation and his economic interests may be directly affected by the kinds of conduct that have been sought to be impugned in this proceeding, particularly in circumstances where I remind myself that the relevant notice from the delegate in part I'm not going to waste my time hunting it down through these pages of tiny font. The net relevant point's this. If this man is to be summarily removed upon a personal exercise of cancellation power, he cannot return to this country for 3 years. Am I right about that?
Yes. My understanding, indeed.
All right. Well, on a view, Mr. Tran, I need you to understand that I reiterate my gratitude for what you've done in effect informing me of where the land lies at present. I have completely dealt with the relief sought in this proceeding, and this proceeding is over. It is going to be extraordinarily difficult for anybody else between now and next Monday, putting it in my terms, to get up to speed if there is to be another, I'll put it, a Tate and Queen type application. So I expect to be fully informed in advance if I am required to continue to be available for any further quia timid proceeding that is to be sought, because on a view, the stakes have now risen rather than receded. And I'm very concerned. I cannot, of course, in any way purport to encroach upon the valid exercise of a minister of executive power, but these parties need to get down to tin tacks. Part of the submissions that have been made in this case, effectively by both parties, it's a reciprocal submission, is that we all play by the same rules. The reason why this Minister for Home Affairs in this proceeding has agreed that the delegate's decision should be set aside is for the reasons set out in the notation. Stated in other terms, those rules were not observed. Now, if I am to be called on short notice to deal with another interim injunction to address conduct by another minister or threatened conduct, including by a delegate, I think as model litigant, even in a proceeding which is not yet on foot, this court is fully entitled to be informed in the way that you have quite properly done this afternoon, and for which I am grateful. Is that clear, Mr. Tran?
If the court pleases, yes.
Nothing further, Mr. Holdenson, I hope. You've heard what I've said.
I've heard what you've said, Your Honour.
Thank you. Adjourn the court.
The Federal Circuit and Family Court of Australia stands adjourned.
This conference is no longer being recorded.
in seeing that the matter could commence today. Thirdly, I'll reserve to Mr. Tran and Ms. Wooten of Council whether the Minister seeks further time to address the Court in making submissions at this hearing, and that will occur once the applicant's submissions have been delivered, which submissions I note are to be completed by midday today. Fourthly, I remind the parties that the current injunction expires at 4 p.m. this day and that issue may need to be addressed before that time. Fifthly, the parties have, as I understand it, submitted jointly a transcript of the interviews undertaken by various members of the Australian Border Force, including the delegate whose decision to cancel the applicant's visa is the subject of challenging in this proceeding. Ordinarily, a transcript of that kind would have been exhibited to an affidavit, a matter which is of some importance. Subject to anything which Council wish to say on this issue immediately, I propose that transcript be marked Exhibit A.
Do not wish to say anything about that, Your Honour.
It's in by consent, Your Honour. Thank you.
By consent, transcript of interviews undertaken by the applicant with various members of the Australian Border Force, including the delegate whose decision to cancel the applicant's visa, which is the subject of challenge in this proceeding, being marked as Exhibit A. Next, just for the sake of confirmation, I have raised with the parties since Thursday and again on Saturday and Sunday the question of public access to the evidence in the proceeding, and my clear understanding and note of this issue is that the parties are content for formal documents such as applications and their submissions to go directly to the public compartment of the portal, as has been occurring, but that their evidence should not move to the public portal unless and until it is read into evidence. That's correct, Mr. Tran?
That is correct, Your Honour, yes.
Mr. Holdenson?
Yes, Your Honour, that is correct.
I will expect then that in the course of the parties' submissions, they will distinctly identify the affidavits which they read. Now, each of the party submissions are directed to the applicant's further proposed originating application and the grounds which are set out in it. Is the grant of leave to file and serve that amended process unopposed?
In the circumstances, Your Honour, it's unopposed because I appreciate that Your Honour has reserved to me and Ms. Wooden the opportunity to seek Your Honour's leave to to take a break to then address Your Honour more substantively and substantially this afternoon.
Thank you. Subject to the submissions of council to be made immediately, I propose to address that issue in the following way. There will be a separate order made. 1, the applicant have leave now for then to file and serve an amended originating application in the form of the further proposed amended originating application being Exhibit NB4 to the affidavit of Natalie Bannister, affirmed 7 January 2022, to direct the applicant file and serve his amended originating application as soon as is reasonably practicable. 3, the respondent's submissions filed 9 January 2022 stand as her response to the originating amended application, subject, however, to any further submissions which may be advanced on her behalf in the course of this hearing. Mr. Holdenson, are you content with an order in those terms?
Yes, Your Honour.
Mr. Tran?
Yes, Your Honour.
Thank you. Is there anything else that needs to be addressed at this juncture?
No, Your Honour.
Your Honour, I feel I have to raise it. I'm not sure if Your Honour received an email from Mr. Quinn on behalf of the media interests.
No, you don't act for Mr. Quinn, Mr. Tran.
Okay.
And I am advised of that email. And as I'm concerned, I may be assisted by some brief observations from counsel, but you have both confirmed with me your affirmation to the adoption of a position that upon matters being tendered or read into evidence, they may go to the portal.
Yes. I don't need to
Yes,
cover
Your Honour.
any further. Yes.
You agree in that, Mr. Holdenson?
Yes, Your Honour.
Thank you. Thank you, Mr. Tran. I'm grateful for that observation. Yes. Mr. Wood, are you proposing to advance the substantive submissions in relation to the Act and the application for judicial review?
Yes, Your Honour.
Is it convenient to commence those?
It is, Your Honour. Thank you. First, Your Honour, what I wish to do is to read into evidence the affidavits on which my client, Mr. Djokovic, seeks to rely.
Yes.
Can I run through and identify them as clearly as I can?
Please.
There are 5 affidavits of my instructing solicitor, Natalie Bannister. The first affidavit was made on the 6th of January 2021.
22.
Sorry, 2022, Your Honour. I read that.
Mr. Wood.
Yes, I haven't had much time to think about it, Your Honour. I read that into evidence, and I will call that throughout my submission as the first Bannister affidavit.
Yes.
No objection, Your Honour.
The second affidavit of Ms. Bannister is dated the 7th of January 2022. And in fact, there are 2 affidavits of the 7th of January 2022. I seek to read both of them in.
No objection, Your Honour.
The fourth affidavit I seek to read in is the affidavit of Ms. Bannister made on the 8th of January 2022.
Is that the 8th or the 9th?
The 8th. This is a 37-page affidavit.
Thank you. No objection.
I will refer to this affidavit to some extent throughout my submissions, and I'll call it the fourth Bannister affidavit. The final affidavit of Ms. Bannister, which I'll call the 5th, was made on the 9th of January 2022. It annexes a media interview with the Prime Minister of this country.
Your Honour, we do object and say that it's irrelevant, but it's convenient if Your Honour just admits it's subject to relevance, and Your Honour can deal with it as Your Honour considers appropriate.
I will do it on that basis, Mr. Tran. The context is that the day immediately prior to the applicant's arrival in this country at 11:30, there was a media release issued by the Minister addressing the question of strict border controls, and I consider that it is relevant to the issues, albeit by way of narrative.
Yes, Your Honour. Of course.
So that's 5 affidavits of Ms. Bannister, Your Honour. The next affidavit that I read is the affidavit of Novak Djokovic. It was, in a sense, made on the 7th of January, but has not been sworn until this morning. It has now been sworn, Your Honour.
Has it now been served in sworn form?
I believe so. I certainly hope so.
Mr. Tran confirms that has happened. Please proceed.
Thank you, Your Honour. And I wish, just for perfect clarity, to note, Your Honour, that before the affidavit was finalised and proposed by my client, there was a minor correction to a sentence in paragraph 22. Can I draw that to Your Honour? Can I draw that to Your Honour's attention? It's very minor indeed.
Yes.
Your Honour sees paragraph 22.
Yes, I do.
The third last sentence starts, when he returned. The correction that has been made is after the words when he returned, comma, Mr. Djokovic inserts the words, and I believed, comma. It's otherwise unaltered.
No objection, Mr. Tran.
2 objections, Your Honour. One's just to overall relevance, but I'm just going to say it should go in subject to Your Honour's determination of relevance in the final judgment, so I don't need to trouble Your Honour further. Can I then ask Your Honour to go to ND4, which is the letter from Tennis Australia? I'm just trying to find that in my... It's on page 15.
Correct.
In my submission, this can go in on the basis of what was before the delegate at the time that he made his decision, so no doubt about that. But in my submission, Your Honour should make a 136 limitation limiting its use so that it can't be used for the truth of what's in there. No doubt it was before the delegate, and I accept it can go in for that reason.
Your Honour, might I respond to that objection?
Of course.
I don't quite understand it, is my response. This case, as Mr. Tran would well know, is a case concerning judicial review. The power of cancellation concerned, first, whether or not the delegate was lawfully satisfied that there was a ground for cancellation. Secondly, if so, whether the delegate lawfully exercised the discretion. The case turns, as all cases do, on the material before the decision maker. My client does not ask Your Honour to find as some kind of objective jurisdictional fact that Mr. Djokovic has any particular status. His status was determined purportedly by an exercise of power of the delegate.
Can I stop you there, Mr. Wood? I reject the objection. I do not think that the document or the evidence is in any sense unfairly prejudicial or misleading or confusing.
Go, please.
The next affidavit, Your Honour, that I seek to read is an affidavit of Carolyn Broderick. It was made on the 7th of January 2022. Carolyn Broderick is the Chief Medical Officer of Tennis Australia.
Your Honour, again, just objection to some relevance, but it can go in subject to relevance, and Your Honour can determine then the final judgment if the court does.
Thank you.
Those are, I believe, all of the affidavits. Your Honour, of course, there is the transcript additionally, which has gone in by consent, and that might perhaps be regarded essentially as an agreed fact for the purposes of Section 191 of the Evidence Act if that formality is necessary.
Well, it's already in by consent.
Yes, well, I think we can
I
move
made
on.
the observation that in the ordinary course, you would have simply exhibited the transcript to an affidavit. I observe and perhaps share Mr. Tran's reservation whether the transcript should be viewed through the lens of a statement of agreed facts. I would rather see it as evidence of the events which that transcript records having occurred.
Yes. No, I think that's correct, Your Honour. Yes.
Thank you. Please proceed.
Thank you. And now, for completeness, Your Honour, just to make sure that Your Honour has got a number of other documents that have been filed in a flurry overnight and early this morning. First
Yes.
of all, there was a reply submission filed
Yes, I
by
have
my client late last night. Secondly, by the same email, there was a chronology, which is in the nature of a submission to assist the court, filed at the same time. Does Your Honour have a copy of that?
Yes, I've had an opportunity to consider that document. It's particularly helpful. Subject, again, to reserving in Mr. Tran and Ms. Wooten any desire to comment, qualify, or address particular events recorded in it, I regard it at first sight as being an essentially accurate chronology of the events, and subject to the reservation in Mr. Tran and Ms. Wooten, which I have just stated, I propose that it be marked Exhibit B.
Subject to that reservation, Your Honour.
Yes.
Me.
That reservation, which occurred at 10:30 today, will be noted. Otherwise, chronology of events occurring in period 18 November 2021 until 7:43 a.m. on Thursday, 6 January 2022, be marked Exhibit B, bracket, subject to reservation in the respondent to correct or qualify entries in that chronology. Thank you.
Thank you, Your Honour. The final point of, just to clarify, is that early this morning we provided a updated version of our original submissions. The only updates were to correct transcript references in light of what is now the...
Yes, I've seen that. I imagine that's not a matter of difficulty.
No difficulty, thank you.
Just designed to avoid Your Honour being confused later, of course. Your Honour, I'll now commence my argument, if that's to Your Honour's convenience.
For your clarification, Mr. Wood, so as to allay perhaps any anxiety at your end, I regard the clock as beginning now.
I'm very grateful for that, Your Honour. Thank you.
I thought you might be.
Yes.
Very good.
Okay.
Please
now,
proceed.
Your Honour, part of the purpose of the chronology is that I hope it avoids the need for me to laboriously set out background in a sequential fashion. I will, of course, be delving in and zooming in to particular features of the story where relevant to the grounds. Can I start?
You should, and so should counsel for the respondent, proceed on the basis that I have had a particular opportunity over the last 4 days or so to immerse myself in the evidence, and one of the reasons for making a preliminary observation in expressing the court's appreciation for the diligence which has been shown by counsel on both sides of this case and those instructing them is that it has put the court in a position where I have a very detailed account of the relevant background, none of which seems to be in particular dispute.
Indeed. Thank you, Your Honour. Can I commence then by setting out just a few elementary matters, but just to confirm matters that we understand are not in dispute, not just as to fact, but as to law. First of all, my client was granted a subclass 408 visa on the 18th of November 2021. Having regard to Section 29 of the Migration Act, I'll call that the Act generally in my submissions, read with Clause 408.511 of the Migration Regulations 1994, that visa, subject to any lawful decision to cancel it, provided positive permission to my client to travel to, enter and remain in Australia. The actual visa located in Bannister number 1 affidavit annexure A. Point number 2, which I don't understand to be an issue, despite public statements that might perhaps be interpreted as suggesting otherwise, there is no other act or instrument that qualified my client's right to travel to, enter or remain in Australia. Nothing in the Biosecurity Act, nothing in the determination made under that Act about which submissions will be made in due course, or any other instrument that qualified that right. There was, in substance, Your Honour, no rule emanating from legislation, no requirement emanating from legislation for Mr. Djokovic to be vaccinated, or indeed any other lawful non-citizen in the sense of the holder of a visa to be vaccinated before arriving in Australia. Mr. Djokovic arrived in Australia on Wednesday night last week around midnight after a 25-hour journey from Spain. He was held in immigration clearance, which is a concept defined in section 172 of the Act at Melbourne Airport until about 7:42 on Thursday morning when his visa was purportedly cancelled by a delegate of the minister. That exercise of power purportedly being made under section 116 sub 1 paragraph E Roman 1 read with section 124 of the Act. This case, as Your Honour readily appreciates from your opening observations, concerns the legality of that purported cancellation decision. If that cancellation decision was unlawful, Your Honour would quash it. The consequence of quashing it would be that Mr. Djokovic still has, and indeed at law has always had since 18 November, the Class 408 visa that he was then granted, and he must be released from immigration detention. I'll address at the end of my submissions whether an order requiring release need or ought to be made, but it follows from the mere fact of the quashing that Mr. Djokovic would have his visa back, and there would therefore be no authority of an officer of the Commonwealth to hold him in detention under section 189 of the Act. Can I briefly mention in passing, Your Honour, noting observations made by Your Honour at an earlier directions hearing about the concept of remitter? Just to be quite clear about this, there is no duty of the Minister to even consider cancelling my client's visa. This is not a case about an application for a visa, where upon receipt of an application for a visa, the Minister or her delegate has a statutory duty to determine it. This was the exercise of a discretionary power. Your Honour would therefore...
I understand, Mr. Wood, I now understand that point.
Yes, thank you. So Your Honour would not order mandamus because there's no duty to which that order would attach.
It would be convenient, and those junior counsel assisting you to furnish both to Mr. Tran and to the court, and I should have said, with respect, Ms. Wooten, those instructing her, a considered minute of the exact order that is being sought.
We will do that, Your Honour.
Thank you, Mr. Wood.
Now, can I now say a few things about legal propositions very quickly, Your Honour, because I don't understand much in law to be the subject of dispute. There is a dispute between the parties that relates to ground 3A of the application. Ground 3A is the procedural fairness ground, as distinct from legal unreasonableness ground in ground 3B. There is a dispute between the parties about the proper construction of section 124 sub 1 paragraph A.
Mr. Wood, this is a common encounter with you and I do apologise for interrupting you. Could you just take your foot off the accelerator a little?
Yes, Your Honour. There is a dispute, Your Honour, between the parties that is relevant to ground 3A of the application about the proper construction of section 124 sub 1 paragraph A of the Act, and in particular what the meaning of response in that paragraph is. I will come to that.
Yes, it's addressed in the submissions and reply.
I will come to that debate briefly in due course. Aside from that dispute, there does not seem to be any dispute about legal propositions identified in our submissions bearing on the availability and lawful exercise of the power in 1161B. And I therefore, given the limited time that I've got, don't propose to run, unless Your Honour would like me to. I certainly can assist Your Honour with a summary of the relevant constraints on the power that relate to the grounds that we advance. Would Your Honour be assisted by that? It would take about 3 minutes.
It would be very useful.
Excellent, I will do that. I'll do it in a series of propositions. Proposition 1, no power of cancellation exists unless a notice is given to a visa holder of the kind described in section 119 of the Act. That follows clearly from the terms of section 119 sub 1, as well as the terms of section 124 sub 1. It is amply demonstrated by binding full court authority. Because it's of some relevance to ground 1A, Your Honour, can I briefly invite Your Honour to look at the case of Ahmed, which is at tab 18 of the joint bundle of materials?
Yes, if you'd bear with me for a moment. Paragraph.
Paragraph 28.
Thank you.
And Your Honour will see, and I'll read out for the benefit of those who watch this in due course. It says it appears clear from section 124 that if notification has not been given under 119, the occasion for the exercise of the power contemplated by 124 has not arisen. Put another way, reading 116, 119 and 124 together, the statute does not authorise the Minister or her delegate to exercise the power under 116 and 124 if the notification contemplated by 119 has not been given. There is therefore, Your Honour, no question of materiality that arises in this context. If the notice has not been given, the power does not exist. I will come back very briefly to deal with whether a requisite notice was indeed given. That's ground 1A. The second legal proposition, which is not, I understand it, in dispute, is that no power of cancellation under 116 and 124 exists unless the Minister or the delegate is first lawfully satisfied that the presence of the applicant in Australia is or may be, or would or might be, a risk to the health, safety or good order of the Australian community. This is what is sometimes called the necessary subjective jurisdictional fact. That state of mind must exist for the power to be enlivened. It is grounds 1C and 1D of our application to which that principle relates, but I don't understand the principle to be in dispute. Principle number 3, Your Honour, of law, which again I don't understand to be in dispute, is that in deciding whether or not the delegate has formed that state of mind that is necessary for the power to exist, there are no freestanding, in the sense of Pico Wall's End, mandatory relevant considerations that bear on the formation of that state of mind, subject to one caveat, Your Honour, which is that implicitly, flowing from the terms of section 119, sub 1, paragraph B, Roman 1 of the Act, there is an implicit obligation of the decision maker, here the delegate, to consider any evidence or submissions provided by the visa holder in response to the notice given under 119, actively and intellectually, before forming the state of mind.
Well, what otherwise would be the point of the invitation?
Precisely. The fourth point, Your Honour, and that's why I don't understand it to be in dispute. The fourth legal point, Your Honour, is this. Assuming the state of mind, therefore, is lawfully formed, that the delegate has lawfully formed a state of mind that Mr Djokovic does, is or may, and so forth, pose a risk, then even then, that only enlivens a discretion, obviously not a duty to cancel his visa. It is grounds 2A and 2B of our application that concern the purported exercise of that discretion. And for the same reason as I mentioned about the need for the delegate to consider evidence and submissions about the formation of the requisite state of mind, it follows for the same reason that the delegate must also consider actively and intellectually any evidence and submissions made by the visa holder before exercising the discretion. The sixth proposition, Your Honour, is that transcending all of the above are procedural constraints on the exercise of power. One being fairness emerging both from the partial code of fairness in the Act, as well as general law concerning fairness where it's not excluded by the code, the partial code, and secondly, reasonableness in the exercise of including procedural decisions made by the delegate. Grounds 3A and 3B concern that final legal proposition, which I don't understand to be in dispute. In those circumstances, Your Honour, I propose to say something very briefly about ground 1A before moving to some of the more substantial grounds that require more elaboration. Ground 1A, Your Honour, concerns whether or not a notice was given. Your Honour will appreciate that the notice, which is in Bannister number 1, and this is a document. Sorry, the best version of the notice, I should say, Your Honour, is Bannister number 2.
Yes.
Annexure H, page 37.
Correct.
Your Honour will see there, this is a document that fulfilled different functions over the course of time. Part A of
Can I clarify one issue with you about this, because it is of some importance to me. You correctly describe it as a composite document. In broad terms, Part A, Part B, Part C, Attachment A, Part A, Attachment B, Part B, an extract of Section 116 together with the regulations, and I think an extract incomplete of the Biosecurity Act. Now, if you put yourself in the shoes of the applicant, sitting, as it were, in a room guarded by the Australian Border Force between 11:30 p.m. on Wednesday night last week and 7:45 on the Thursday morning, the first observation you might make when you look at this composite document is that, save for a very small number of signatures and initialed times and dates, the entirety of the documents, plural, are in typewritten form. Now, you may wish to say something or nothing about the manner of their preparation in typewritten form before they are given to the applicant, and relatedly, I might be assisted by some submissions which play out, as it were, the manner in which a person, a detainee or an interviewee in the position of the applicant, receives in succession Part A and then Part B together with the annexures and copies of the legislation, and then Part C, which is the decision. You can see, if you look at it from the opposite end of the spectrum, it's absurd to think that the delegate arrived at 4 a.m. and gave to the applicant a copy of Part C before there'd been any interview or any opportunity taken by the applicant to say, I want you to hear my side of the story. Can you assist me with some detail as to this in a perhaps logistical or linear sense?
Yes, Your Honour. It's right to characterise it, even though it's packaged here before the court, as though it's one document. It's actually multiple documents. The first document, which is Part A, so it's pages 37 through to page 42, Your Honour, is the first document and the only document that was given to Mr Djokovic in the first phase at about 3:55 a.m. on Thursday morning. It was what's sometimes called the NOIC, the Notice of Intention to Consider Cancellation.
Now, Mr Wood, you're going to have to drag yourself back to the last century. I hate acronyms.
I'm glad to hear that, Your Honour. And I'm sure that the audience that watches this will be will share that concern. I'll avoid them.
So there'll be no NOICs and there'll be no oinks and there'll be nothing else of that nature.
At 3:55 a.m, Your Honour, Mr Djokovic was given Part A. It was the purported notice under Section 119 of the Act. He got no other document at that point in time.
Correct.
Your Honour is right that everything, save for signatures, is computer printed text. What I want to point out about not only Part A, but the balance part of Part B and Part C as well, is that clearly enough, there is pre-printed text in these documents, that they are forms generated by the department for use. And then there has been printed text inserted in relevant parts of each of these documents.
Of course.
And what has happened is that in the box on the right-hand side of page 37, under the heading, include the specifics, brackets, particulars of the ground and the information because of which the ground appears to exist.
Yes.
It says see attachment A. I'll turn to attachment A, which is at page 41. So this is the purported expression or performance by the delegate of the obligation in 1191A to give notice, to give particulars of the grounds and so forth and the information.
Just before you do that, Mr. Wood, would those assisting you please make note that it is not immediately apparent to me where the document entitled Annexure B, Part B, is expressly referred to within the body of any of Parts A, B or C of the formal cancellation notices, but it seems implicit from its content, and I think this might be common ground, that it is the repository of part of the reasoning or the whole of the reasoning in Part C for the actual cancellation decision itself.
Your Honour is absolutely right, and the way that we see attachment B is that although it's not been cross-referenced, in context it is to have been the expression by the delegate of the basis for the formation of the state of satisfaction that a ground for cancellation existed. It is not the expression of the exercise of discretion, because there's no mention there of any of the discretionary matters. It is essentially, Your Honour, the re-expression of the very same in substance matter set out in attachment A, which was the performance by the delegate of the 119 duty to identify the particulars of the ground that it appeared the delegate existed for cancelling.
Can I stop you there in relation to this? And you will be highly familiar with the text of the pro forma document. But one of the aspects of it which may warrant some comment, and I raise this for you in order, as much as anything, to give counsel for the minister some opportunity to address it. But I think it's accurate to say in each of parts A, B and C that it's explicit that the only ground that is statutory ground being relied upon is paragraph 1161E Roman 1. Stated in other terms, the opportunity using this tick the box mechanism which is provided to engage or indicate that the delegate regarded paragraph 1161D as being engaged is clearly not being addressed, and by extension, or perhaps relatedly, nothing in any of the extensive grounds provided throughout Regulation 2.431, and as importantly perhaps, nothing is provided in relation to another ground which is given the umbrella description other.
Correct.
You see that?
Yes.
So if there was some other ground, that other ground is not being relied upon. The only ground, therefore, the boundaries of this universe as set by the delegate lie solely within the ambit of paragraph 1161E Roman 1 and nothing else.
Correct.
Thank you.
Can I make two observations now about Part A? So this is the Section 119 notice.
Yes.
First of all, and this is relevant to Ground 1A, where the form says on page 37, include the specifics, particulars of the ground and the information because of which the ground appears to exist, it takes the reader to attachment A.
Yes, it does.
The final paragraph of attachment A expresses a purported state of satisfaction that a ground exists, being that the minister may cancel a visa if he or she is satisfied that if its holder has not entered Australia or has so entered but has not been immigration cleared, it would be, quote, liable to be cancelled under 1161E1. That is a mashup, Your Honour, of paragraph D and E. It does not represent a ground that exists in the Act. It is not a typo, Your Honour. It is more than a typo. It's a confusing blend of two distinct grounds of cancellation. And
textually, Mr. Wood, when one looks at each of paragraphs 1161A, AA, B, C, D, E, Roman 1, Roman 2, F, and FA, Roman 1 and 2, and G. It is beyond argument, it seems, that these are disjunctive grounds at the end of every single one of them. Or. So A or B or C and so forth. And that is why I asked you the question that the only ground is paragraph 1161E, Roman 1.
Correct.
Nothing else.
Correct. And the problem, Your Honour, which is ground 1A, it's a very short point. The problem, though, is that even though the delegate identifies 1161E1, the delegate then expresses the ground in the final sentence of attachment A in terms that do not reflect the Act. It therefore follows, Your Honour, and this is the shortest point of the case and the most legally technical, if you like, that bearing in mind the proposition from Ahmed, which I took the course, there hasn't been a compliant notice issued and the power to cancel simply does not arise. That's all I wish to say about ground 1A. The same point emerges when in 1B in a different location. It emerges in part B of the decision record where, I'm looking at page 45 of the affidavit now, Your Honour, in exactly the same way, in point 7 on page 45, the final paragraph, the delegate says, based on the above information, I'm satisfied that there are grounds to consider cancelling and so forth. The ground is that the minister may cancel if he or she is satisfied that, and then enters the mashup language again of D and E, a ground that doesn't exist. So
Can I try and unravel this by reference to what you've said in relation to Ahmed? Working backwards, and please correct me if I've misapprehended this, working back from paragraph 1161E Roman 1, that is a freestanding basis upon satisfaction of the subjective jurisdictional fact you've referred to for cancellation. But as I've understood the submission, if, and this may be inaccurate, but if paragraph 1161D or a related or similar provision was to be engaged, there needed to be notification. Correct. And that didn't occur.
Correct. So, Your Honour, the way I put it is this, if this assists. The point, ground 1A, the point is the notice was defective.
Yes.
Ground 1B is, moreover, in any event, in light of 116 of the Act, the minister can only cancel a visa if she is satisfied of a relevant ground. And the only expression of the state of satisfaction in this document, in part B, the decision part of the document, not the notice part of the document, is the final paragraph, point 7, page 45, and the delegate expresses a state of satisfaction that a certain ground exists, but the expression of that ground is a mashup of D and E. And so we don't have the requisite state of satisfaction, therefore, similarly, to enliven the power. So it's fundamentally the same point. It emerges at 119, notice is bad. It emerges in the same way at the 116 end, because the state of satisfaction that's necessary in order for the power to be enlivened doesn't exist.
So can I stop you then, Mr. Wood? I know that you've said more than once that it's a short legal point, but if this is a proper construction of the provisions having regard to the narrow way in which the delegate has acted, the case would collapse at this point.
Correct.
Now, the next point that I need your assistance with is this. It's all well and good to describe something as a short, narrow legal point, but your submissions identify squarely the significant reputational, financial and professional implications, in this case, for your client, but similar implications could arise for anybody who was a person that held a valid visa on entry and who sought to pass through immigration clearance with all of the documents considered to be necessary. What I'm leading you to and asking for your assistance about is this: whether or not it is a sufficient description of this ground as being short, narrow, legal. on a view, it would seem that the importance of the notice, and then in turn the importance of the invitation, and then in turn the importance of the opportunity to respond to the invitation, and ultimately the importance of the obligation to give considered and reflected evaluation of whether or not to cancel a visa serves to magnify rather than dilute the significance of this short legal point.
I agree, Your Honour. My description of it as short represents only the simplicity of the argument. It is not intended to dilute the significance of this process in the Act, the need for a notice of the kind that 119 describes, the vital function that that notice performs, and the obvious need for the minister or the delegate to form the precise state of mind that is necessary in order that there be power to cancel the visa of my client, Mr. Djokovic, or any other client or any other person in a circumstance similar to which he faced on arrival at an airport.
Thank you.
Can I move now then to grounds 1C and 1D? Where they fit, Your Honour, into the picture is that both grounds 1C and 1D are concerned with quite particular complaints that we make about the purported formation by the delegate of the state of satisfaction that the relevant ground exists. Let it be assumed for the sake of argument that I failed on ground 1A and 1B, and so I'll treat the ground here as being 1161E1 properly understood, risk to the community and the like. Can I take Your Honour back now to the what I'll call the decision record? So we've now moved beyond Part A, and we're looking at Part B. Yes. Record of decision whether to cancel a visa. First of all, just to be clear, and I'm sure that Your Honour has picked up how this document works structurally, but I'll make a few points just so we're quite clear about it. So on page 43, the right-hand column, it says grounds for cancellation provide a summary of why the visa holder considers grounds for cancellation do or do not exist. So this is a box where the delegate records in summary form what Mr. Djokovic had said as relevant to whether the ground exists, not the discretion, the ground. In other words, whether there is or may be a risk to the health of the community and so forth.
I'm sorry, Mr. Wood, which item in Part B are you referring to?
It doesn't have a clear item. It's in the right-hand column of page 43. In unbolded text, it says ground for cancellation. Underneath that, it says provide a summary of why the visa holder considers the grounds for cancellation do or do not exist.
Look, Mr. Wood, I'm sorry to stop you about this, but you know that over the course of the weekend, the court's been concerned to try to unravel and obtain an accurate and complete copy of this notice and its various parts. You need, unfortunately, to work from an assumption that I'm looking at what I consider to be the most easily understandable version of this document. And in Part B, if you just work for my purposes, my page is numbered 34. Don't worry about that. But on Part B, on that page, items 1 through 5 exist. And then in the right column, you've got grounds for cancellation.
Correct.
And then you go over the page and you see item 6, and then the right column, item 7, and so forth. So the most natural way to read this document is to read down the left column, go back to the top of the right-hand column and down and so forth. And that would mean that the grounds for cancellation considered by the visa holder for not cancelling the visa are those set out in that column.
If you would permit, I'd put it slightly differently to try to be quite clear about this so that we don't misunderstand each other, Your Honour.
Thank you.
In that column is the delegate summarising what the delegate thought Mr. Djokovic was saying
Exactly.
as to why the ground doesn't exist.
That's exactly right.
Yes, thank you. Then if we turn the page, so we move past the fine print with the extracts of legislation, we turn the page, we get to point 6.
Yes.
The delegate records a state of satisfaction that a ground exists, 1161E1. Then we get to the most significant part of this document relevant to this ground. That is point 7.
Yes.
It says, and this is important, Your Honour, details of the evidence and findings about why the delegate is satisfied grounds for cancellation do exist. So effectively, Your Honour, the pre-printed form asks the delegate to set out the reasons, or more precisely, the evidence, details of the evidence and findings. I'll say something in a moment about the utter paucity of evidence that is set out therein. Of course, it always remained open to the delegate to go beyond the box, to include an annexure. That's the very thing that was done, Your Honour, obviously in Part A of the document with Annexure A. It was not done here, but it may well be that Annexure B is an effective expression of the same content of point 7. Now, can I invite Your Honour to observe a couple of things about point 7. I start with this proposition. The final paragraph of point 7 says, based on the above information, I'm satisfied there is a ground and so forth. What that clearly does is pick up by cross-reference everything that is said above, as we say cumulatively, forming the basis for the formation of the requisite state of mind by the delegate.
I'm sorry, I'm sorry to cut across you, and I understand the force of that submission. Do you, as it in the sense of a Venn diagram, treat that final sentence or paragraph based on the above information I am satisfied as meaning based on only that information and nothing else?
All and only.
That's right. Thank you.
And the significance of the all, Your Honour, and we've referred, I won't take Your Honour to it, but we've referred in our written submissions to a full court decision called ARG 15. It's tab 6. I won't take Your Honour to it, but Your Honour may read paragraph 73 and 74 in due course. And a similar expression at the back end of the reasons was provided by the tribunal in that case. And the full court said that means necessarily that, or it expressed as a matter of evidence, that the matters that had been set out above cumulatively gave rise to the state of satisfaction. The consequence of that is that defect in any of the elements set out above in terms of the reasoning infect the ultimate conclusion. And one can't, if you like, try to artificially separate out strands and say, well, that bit in the paragraph above, there's no problem with that statement, and so therefore somehow the decision was sound, the state of satisfaction was lawfully formed. Can I say something else about the structure of point 7, Your Honour? Paragraph 1 of point 7 really doesn't summarise reasoning. It records things, summarises things that Mr Djokovic said during the interview. Then we go to paragraph 2, starting under the Biosecurity Act 2015. This is where things get interesting. It says, under the Biosecurity Act, there are requirements for entry into Australian territory. These requirements include that international travellers make a declaration as to their vaccination status, vaccinated, unvaccinated, or medically contraindicated.
Yes.
And travellers may make a declaration they have a medical contraindication. That's been one of the 3 options, obviously. And then, and I underline, must provide evidence of that medical contraindication provided by their medical practitioner. If that was intended to be the expression of what section 5 sub 3 of the relevant biosecurity determination, it's patently false. Section 5 sub 2, read with sub 3 of the determination made under the Biosecurity Act, simply requires a declaration of which of the 3 categories the traveller is in. It does not require the traveller to provide evidence of those matters. 3B Roman 2 of the Biosecurity Determination simply says that this version of the declaration is the individual declares they've got a medical contraindication to COVID-19 vaccines and I quote, can produce evidence provided by a medical practitioner of that matter. The reason why this is important, Your Honour, is this. Can I take Your Honour back to Annexure A, which was part of Section 119 notice? So Attachment A, Your Honour, the next page, which was really part of Attachment A, was what is entitled Biosecurity Act 2015 reference.
Yes, indeed.
That's a misnomer, but we don't take anything from that criticism. It's not a reference from the Biosecurity Act. It's a reference from the Biosecurity Entry Requirements, Human Coronavirus with Pandemic Potential Determination 2021. The relevant point is that the only bit of that determination that is extracted there is an extract from Section 5, Sub 3 of the determination. That, in other words, is the part of the determination that, read with Sub 2, requires a declaration of status, in effect. And that declaration of status was made. Mr. Djokovic made a declaration that he had a medical contraindication. He was not required, as part of that declaration, to provide evidence, even though, as a matter of fact, he did. So
Mr. Wood, at some stage, you may wish to make some submissions expanding upon the questions of construction or the proper approach to construction of these sorts of determinations. Both counsel have addressed in broad compass, on a reasonable assumption, settled principles respecting the proper construction of, and I emphasise this for you, in order, legislation, and then secondly, regulations, and then thirdly, subordinate regulations, and perhaps fourthly, a determination of this kind, and it may have particular status that I need to have my attention drawn to, but there seems to be a point, perhaps two, at which the approach taken, if you will, to legislation stands in contrast with the more practical approach to be taken to the consideration of subordinate legislation. The authorities contain some suggestion that choose workplace regulations. They're to be understood by the people on the shop floor. Contrastingly, you've got a determination which finds its genesis in a Biosecurity Act. And it just preoccupied me a little, because your primary submission is that there is no relevant requirement. And you put that challenge front and centre at the feet of the respondent. And part of this that is perhaps of assistance in trying to think it through is perhaps through Section 499 of the Act, with which you're all well familiar, but in terms, the Migration Act confers power for the Minister to give written directions. And you see that all the time. Every week, people come in and my attention is drawn to these documents, PAM, and I think IMMI documents, and subsection 499(2)A effectively provides expressly that a person or a body must comply with the direction under subsection 1. Now, I know that this is a point that lies sort of in parallel or in tandem with your threshold issue, but one way of reflecting on this problem that's arisen in this case is the well-worn idea that if the Parliament, as it's often said, had wanted something to be a requirement, it would have said so. If there was to be regulation saying you must do X, the regulation would say so. Now, these biosecurity determinations have some sort of status here, but they don't have the status of a 499 type direction. Have I got that much right?
Can I make a few responses, Your Honour?
Please.
For a start, I understand when Your Honour refers to 499 of the Migration Act, Your Honour might do that by way of useful analogy in terms of an appreciation of the type of approach one takes to instruments or directions issued under 499. Of course, nothing's been issued under 499 that matters here. Okay.
I agree.
Yes. The second point I would make is that the instrument issued under the Biosecurity Act, so this is the biosecurity determination, carries criminal consequences for breach. That flows from section 46 of the Biosecurity Act itself. And I'll just read it out. Your Honour may not have it before you. So,
can you give me a minute, please?
That suggests.
Please go on.
So section 46 sub 1, Your Honour, of the Biosecurity Act
Yes.
says an individual to whom a requirement determined under section 44 brackets entry requirements applies must comply. Civil penalty and so forth.
Yes.
The biosecurity determination that we're concerned with, Your Honour, was made under section 44 of the Act. So as a starting proposition, one would construe it in accordance with the usual principles strictly. In any event, one would expect quite clear expression of exactly what is required and what is not.
Well, again, the force of that submission wouldn't it, be magnified by the express provision of civil penalties, which perhaps someone like Mr. Holdenson might immediately. I'm now having real.
I'm hearing an echo, Your Honour.
I'll put it briefly. It might have been the point that penalty units were not a very large amount, but 30 penalty units for a contravention of this type of requirement would again magnify the importance of strict compliance.
Absolutely. Now, can I make my third point in response to Your Honour's question?
I'm sorry to take your time up.
No. I just signalled at the outset, Your Honour, I absolutely appreciate the time limits Your Honour has imposed. I do want to assist you with answering questions. It only helps my client and it can only help Your Honour. If I feel I want to ask for an extension at the end of my submissions, I may do so, but we'll cross that bridge when we get to it.
Yes, and it won't be a bridge you need worry about until about 1:45 p.m.
Thank you very much, Your Honour. So can I explain this, Your Honour? Can we come back to section 5 of the biosecurity determination?
Yes.
Can Your Honour look at subsection 2? Recalling that the extract given in the notice under 119 of subsection 3, which intersects with subsection 2, right? Now look at subsection 2. It says the individual must be able to produce to a relevant official evidence that before the individual boarded the aircraft, right? So this is in Dubai, in Mr. Djokovic's case. Before Mr. Djokovic boarded that aircraft, he made a written statement that included a declaration mentioned in sub 3. Then you go to sub 3. And that requirement of the content of the declaration is effectively a declaration as to whether or not the traveller fits in within category A, category B, or category C. And that declaration was made. And Mr. Djokovic said, I fit into category B. I have a medical contraindication to COVID-19 vaccines. The point that is of relevance to ground 1D, which is simple and for myself, I cannot understand how it can be answered, is that B2 says, 3B2 says the individual can produce evidence provided by a medical practitioner. It is plainly not required at this stage of the process. In other words, while the traveller, before the traveller has boarded the aircraft, to produce the evidence, he simply has to declare that he can do so.
Again, now, pausing there, Mr. Wood, when we get to about 4 a.m. and travel through to about 6:30 a.m. on the morning of last Thursday, the transcript is replete with statements by Mr. Djokovic saying, if you will let me talk to people, although you've taken my phone from me, I will try and get you what you want.
Indeed, Your Honour. Beyond that, in a sense, there's a degree of artificiality or mootness to this whole discussion, because not only was Mr. Djokovic doing his level best to provide to the officer at Tullamarine everything that he wanted, and did indeed provide material to that officer, but Mr. Djokovic, and I'll come to this in due course,
Sure.
did indeed provide that material, that evidence from medical practitioners before he boarded the aircraft. Now, but park that for a moment. I just want to be as clear as I can about the point we're trying to make here on it. Now, if we can go back to the biosecurity determination, we've talked about sub 2 and sub 3. Can I take Your Honour to sub 7?
Yes.
A distinct requirement. It says, if a relevant official asks the individual to do so, the individual must produce, and then go here relevantly to B, if the declaration included the individual statement was of the kind mentioned in 3B, which is the case here, the evidence mentioned in subparagraph 3B2. So it's a very clear and distinct process. You make the declaration before you board the aircraft. You say, I declare my status unvaccinated, medical contraindication, and you declare that you can produce the evidence. Later, only if you're asked under sub 7, do you have to provide it, the evidence. Now, the point that matters here, Your Honour, is come back to attachment A, recall the function of the section 119 notice of which attachment A was part. Your Honour will recall that under the Act, and the cases are crystal clear about this, the decision maker, in advance of making the decision, must provide particulars of the grounds. The only relevant particular that was provided here, so far as it relates to the biosecurity determination, was section 5, sub 3, not sub 7. So Mr. Djokovic was never even notified, as he would patently be required, if indeed later the decision maker was to decide that there was a ground flowing from something else, but he was never notified under the 119 notice that he had breached sub 7 by failing to, quote, produce evidence relating to his declaration on request. He was only ever notified of a particular of the proposed ground of cancellation, implicitly that he had not complied with section 5, sub 3. But that obligation was only to make a declaration, not to provide evidence.
I understand it.
Thank you. So, Your Honour would probably appreciate, therefore, why this, yet again, not to undercut its significance, but legally is a very simple point. Let's come back to part B of the decision record, which sets out the reasons, or more precisely, details of the evidence and findings. We were looking at paragraph 2, and I make the point that the middle sentence, in context, has to be read in light of the section 119 notice that cited only section 5 sub 3 and not section 5 sub 7, can only be understood in context as suggesting that the declaration that is required to be given under sub 3 must be accompanied by evidence of the medical contraindication, manifestly incorrect at law. Now, beyond that, Your Honour, skip over the remainder of that paragraph and skip over the next one for a moment and come to the fourth paragraph that says, all visa holders, whether permanent or temporary, are expected to abide by all public health directives issued by both Commonwealth and state and territory jurisdictions. A breach of these directions
Not. The court will adjourn briefly.
The Federal Circuit and Family Court of Australia stands temporarily adjourned.
Might still be on.
Open the court.
Silence. The Federal Circuit and Family Court of Australia is now in session, recalling the matter of Novak Djokovic v Minister for Home Affairs for hearing.
Please continue, Mr. Wood.
Thank you, Your Honour. We were looking at paragraph 4 of point 7, and I read it out to Your Honour. That the substance of it is it says, all visa holders expected to comply with public health directives issued by various jurisdictions. A breach is considered a potential risk to the health, safety or good order of the Australian community. That paragraph can only sensibly have been included in this part of the document, which invites, quote, details of the evidence and findings about why the delegate is satisfied the grounds exist, particularly in light of the statement in the final paragraph, based on the above information I am satisfied. It can only sensibly be understood as forming part of the delegate's reasons for why Mr Djokovic was considered to be a potential risk to the health, safety or good order of the Australian community. The only legislative provision that might be capable of being characterised as a public health directive issued by any of the relevant governments is that which was identified in the section 119 notice, and that is section 5 sub 3. It is manifestly not the case that Mr Djokovic breached section 5 sub 3 of the biosecurity determination, and any conclusion to the contrary is clearly erroneous. What Mr Tran and Ms Wooden submit, Your Honour, is that one is to, in effect, generously read point 7 and assume that what the delegate is speaking of is section 5 sub 7. That submission cannot be accepted for two obvious reasons. Number one, as I've been at some pains to try to explain, section 5 sub 7 was not particularised as a basis upon which the ground for cancellation existed in the section 119 notice. So if it is now sought to be reconstructed as, in effect, what the delegate meant, then one would have the clearest jurisdictional error imaginable, which would be a finding that a ground exists based on a matter that hadn't been the subject of the section 119 notice, which required particulars of the basis upon which the delegate appeared to think the ground existed, just QED. In any event, Your Honour, it would be erroneous because Mr Djokovic did provide evidence both before boarding and after arriving at Tullamarine of the matter. Now, can I take Your Honour to an important piece of evidence? Can I take Your Honour to Bannister Affidavit number 4?
Yes.
Bear with me. Bannister Affidavit number 4, in the body of it, records, and I won't bore Your Honour by going through all of the email chains, but in substance records the fact that Ms Bannister continually asked AGS, I'm not being critical of AGS, but we kept making requests as soon as this situation emerged on the early hours of Thursday morning for the material before the decision maker and what was on the records of the department. What ultimately came back relevantly to this point is the document at page 35 of the affidavit.
Yes.
It has the heading ATD for Novak Djokovic.
Yes.
Oh, here's TK. We're in.
Can I ask whoever is on screen to make sure they mute themselves? There is every importance that the only people who should be online with their microphones are those who are making submissions to the court. Any other behaviour by any person who may be wishing to watch this live will produce a very real risk that the bandwidth available for this hearing will be overwhelmed and the hearing will be interrupted, and that is utterly unacceptable. Please continue.
Thank you, Your Honour. So if Your Honour is at page 35, you'll see that document is headed ATD, which can be taken as meaning Australian Travel Declaration for
Yes.
Novak Djokovic. This is the document that was completed by Mr. Djokovic or his agent before his arrival in Australia. It was the form prepared by the government to facilitate compliance with Section 5, Sub 3 of the Biosecurity Determination. If we turn the page to page 36, you'll see question 9. It says, please provide your vaccination status, and therefore a series of boxes are provided, yes or no, that enable a traveller to comply with the requirement in Section 5.3 by making the requisite declaration. And Your Honour will see 9.1.1, again part of the form, says, I declare I cannot be vaccinated for medical reasons. I'll come back to this document in relation to a later ground, but for present purposes, Your Honour will see that the box yes is ticked. The declaration, therefore, is made. Moreover, 9.1.1.1 says upload proof that you are unable to be vaccinated for medical reasons. And indeed, as I'll seek to demonstrate to Your Honour later, that proof was indeed uploaded. What was uploaded was the medical exemption document that had come from the Chief Medical Officer of Tennis Australia that recorded...
Can I ask you to pause here, because it's a matter that has really preoccupied me. The status attaching to this medical exemption the applicant in this case, as with perhaps the vast majority of persons who may be seeking Mr. Wood to enter with a valid travel permit, together with, if it was the fact, a medical exemption rather than a vaccination, can be assumed not to be a specialist medical practitioner. The whole structure of these contemplated arrangements is that one would go elsewhere to a medical practitioner to obtain the exemption. It would be, you'd think, absurd that a person could issue the medical exemption for themselves. And by extension, the evidence in this case serves to underline what seems a relatively significant fact, particularly in the context of cancellation of a visa once a person had arrived, that here a professor and an eminently qualified physician have produced and provided to the applicant a medical exemption. Now, further to that, that medical exemption and the basis on which it was given was separately given by a further independent expert specialist panel established by the Victorian State Government. And that document was in the hands of the delegate. And the point I'm somewhat agitated about is, what more could this man have done?
I agree, Your Honour. Can I make a global observation about what happened at the interview? I won't go into detail for a moment, but I will in due course. What emerges with utmost clarity from a review of the transcript of the interviews that Mr. Djokovic was subjected to at the airport, combined with his own affidavit describing interactions with officers when the tape was off, was a repeated appeal to the officers with which he was dealing that, to his understanding, uncontradicted, he had done absolutely everything that he understood was required in order for him to enter Australia. He had engaged with Tennis Australia. They had facilitated, or that they had received his application for an exemption. That application for an exemption had been assessed by that eminent the members of the eminent members of the two panels to which Your Honour has referred. A document that is of great significance to another ground that I'm going to come to in a moment, Your Honour, is not only that, but observe at the moment that this is the declaration being made under Section 5.3. Observe that he did, so this is before boarding the aircraft, attach evidence in support of the declaration that he made, being the medical exemption certificate, which one sees on the very next page, page 37. You see the top medical exemption certificate attached. So this is the document that was uploaded with his declaration, and therefore in advance Mr Djokovic provided the evidence that, any evidence that might have been required, even though Section 5.3 did not require it to be done at that point in time. And it said what it said. So I will come in due course to a later document that was issued by the federal government, which is of great significance to another ground. But just so Your Honour can see where this fits into the context, the later document came from the federal government, from the Department of Home Affairs indeed, the substance of which was saying, in response to the declaration made here and the attached medical exemption certificate, that his declaration had been, quote, assessed, and that document was clearly capable of being understood and was understood by Mr Djokovic as meaning that the federal government thought he was okay to come.
Pointing here, this is not unimportant. The process of assessment raises the anterior question of assessment by whom. And the reason I put it in that context to you, Mr Wood, is that the transcript is replete with a sort of back and forth about what's been given by the federal government, what's been given by the state government, what's been given by Tennis Australia. And Mr Djokovic is quite candid. He says, look, if I've got these facts wrong, I'm sorry I'm mistaken about it, but I understand I've given you everything that you want. And in effect, I wouldn't have even come here unless you had. Indeed, and more than that, this is the point that I'm asking you to assist me with. The assessment of the travel permit or declaration is only an assessment by a federal body.
Correct. Can I take Your Honour to that document? Because I think it assists in light of what we've been discussing, Your Honour. So can I take Your Honour to the assessment? We've looked at the actual declaration made, which is relevant.
Make sure you get it on the transcript for the page and reference, please.
Yes. Can I take Your Honour now to the first Bannister affidavit? That's where I find the assessment document. And it is Annexure G to the affidavit of Natalie Bannister made on the 6th of January.
Thank you very much.
Now, Your Honour will see there is large bold text with the Commonwealth crest. It says Australian Government, underline, Department of Home Affairs. Then says, Dear, redacted. We have received your Australia Travel Declaration, in other words, ATD, as referred to in the previous document that we were looking at, on 1 January 2022 at a certain time. Then it says status, bold. Then it says bold type. Your Australia Travel Declaration has been assessed. Underneath that, it says in non-bold, your responses indicate that you meet the requirements for a quarantine-free arrival into Australia where permitted by the jurisdiction of your arrival, referring relevantly there here to Victoria. No problem with Victoria. So take a step back. Mr Djokovic has made the declaration required under Section 5.3. He's provided evidence in support of that declaration, even though it wasn't required by the instrument at that point in time. Then what happens is, after making that declaration, he or his agent receives from the Department of Home Affairs, being the department that assists the respondent to this proceeding, a document that says your Australia Travel Declaration has been assessed, and your responses, which must necessarily include the evidence that he uploaded in support of that declaration, being the medical exemption certificate from the CMO of Tennis Australia that referred to the eminent medical practitioners and recorded what it recorded, your responses indicate you meet the requirements for quarantine-free travel. Now, what is someone in Mr Djokovic's position supposed to understand? Any reasonable person would understand, and he did understand, that he had ticked absolutely every box. Now, all of this, Your Honour, to put it in context, is highly relevant to the grounds that we advance about the exercise or purported exercise of discretion, if indeed a discretion was enlivened here by the delegate to cancel his visa. Let me just put it in a summary so everyone understands the point. Even if the 119 notice was valid, it wasn't. Even if it was open to the delegate to be lawfully satisfied that Mr Djokovic is or may be or would or might be a risk to the health of the Australian community, that then opened up a broad spectrum discretion about whether or not, notwithstanding the state of satisfaction, the visa should in fact be cancelled. And what Your Honour was putting to me a moment ago is that the overwhelming impression that is formed on reading the transcript is that Mr Djokovic in the early hours of Thursday morning was continually saying, I'm utterly confused in substance. I've done everything that's been asked from me. And in particular, and I'll take you on to the transcript references in a moment, kept referring back to the very fact that he'd got this assessment document from the Department of Home Affairs, which says what it says. And he was saying, if there's been an error, I don't understand what it is. I would like some time to speak to lawyers in Tennis Australia and so forth, which time was denied. That's the subject of a different complaint.
Well, I'm sorry. I thought on a view of the case being advanced and the evidence in the transcript, it's not a case of time being denied. It's, in fact, objectively, broadly, an agreement to give time, which is then reneged upon.
Correct.
So the relevant idea, if you will, you know, in the waking hours of Thursday morning, 4 a.m, a person is instructed to and complies with an instruction to turn off his phone. And as your submissions put it, he is effectively incommunicado for the entirety or the vast majority of the period from between around midnight until 7:42 when the cancellation is effected. And he is putting to the delegate or the person who keeps running in and out of the room, apparently asking for instructions, what do I do next? I think if you would let me have enough time so that when Tennis Australia is awake, when my agent is awake, and when I'm able to communicate with them by telephone, we can effectively, in a meaningful way, take up the opportunity which is embodied in this invitation to provide you with anything more that you might want. But what happens is something completely different.
And indeed for him to even understand what on earth was going on, given all that he'd received back from both Tennis Australia representing what the product of the independent panel was, but moreover, and importantly, the document that came from the Department of Home Affairs itself, which indicated that his ATD, which included the exemption certificate that he passed on, or uploaded, had been assessed.
Do you understand it is any part of the respondent's case that when your client said, for example, at transcript page 23, line 30, I would like to postpone it to 8:30 if possible, comma, yes, that being but one of the requests he made throughout the night?
I agree.
The delegate said, no, that's not on. Wasn't the burden of the exchange with the relevant delegate on a fair reading of the whole of the transcript, yes, you can, until it was recanted at the point when the cancellation decision was given to him?
Yes, and can I add two things by way of...
But does that overstate the position, or do you think that's accurate?
I think it's accurate, and what I wanted to do was to augment it by contextualising it in two ways. First of all, what happened, and I'll come to the detail in a moment, I've got detailed references I want to make to Your Honour, but in substance what happened was two things. First of all, the delegate, at a point during the interview process, was indicating to Mr Djokovic that his shift was about to come up. Yes. An interesting feature of the story when one might understand why it was that ultimately there was a reneging from the agreement to allow Mr Djokovic reasonably until 8:30 to speak to Tennis Australia and so forth. But moreover, and what's even clearer, is that there was the articulation by both the delegate and a senior officer of what I can only describe as spurious rationales for why, in effect, it was said to be in Mr Djokovic's interest to have the decision made without him getting assistance of others.
Well, this is part of the reason why I ask you about the format of Part 8, B and C and the manner in which these documents are progressively populated over the course of the night with all of the typed information, which is then given to the applicant and signed by the delegate, and the date and time of it being given to him inserted. Because on a view, it almost, and I think particular caution is required here, but it has the quality of this ex post facto view. I'm coming in with a cancellation decision. It embodies in type form the basis on which I've made the decision. And then we have these people saying, look, getting in touch with your lawyers is really not going to help any of this, so why don't we just get it done?
And the proposition that Mr. Djokovic couldn't possibly obtain assistance from lawyers or Tennis Australia is manifestly erroneous. It would only be true if the delegate had a closed mind. Otherwise, there were obviously things that Tennis Australia, his lawyers and other people might have assisted, his agent might have assisted Mr. Djokovic with, either in persuading, in understanding how, despite all of the indications he'd received that he was okay to travel, in assisting him to understand why it might be that he's not, in assisting him to articulate why indeed a ground did not exist, but most obviously and clearly in assisting him to make arguments to the delegate that even if somehow it was open to the delegate to conclude that he did indeed pose a risk to the Australian community, that in all of the circumstances where he'd been led fairly to believe that he was okay to travel, and given who he was and what he was here for, the limited period of time to participate in the Australian Open, that given all of the circumstances, the discretion might indeed have been exercised not to cancel his visa. That these are all matters that he would have ably got assistance from his lawyers, from Tennis Australia, from the members of the legal profession in this room, but that opportunity was denied on the spurious basis that there was nothing possibly that anyone else could do that could possibly assist him, and it was in his interest that a decision be made, and then the lawyers might only help later to do what we're doing right now, which is to undo that very decision.
Can I ask a question? I know and understand, I hope, why it is that you say remitter's not an issue, but nonetheless, is it of some relevance to assess the matter through the lens of materiality? If you think about the threshold settled now by the High Court as to the possibility that there could have been some other outcome had the opportunity been actually extended to Mr. Djokovic in a meaningful way. The burden of your submission, Mr. Wood, as I understand it, is that all of those facts and circumstances compel a conclusion that if he'd been given a fair opportunity to deal with what he wanted to deal with by 8:30, there is a real possibility that he would have.
Undoubtedly. Can I mention a case? If Your Honour feels comforted by a High Court case, let me give it. There was a High Court decision last year in a case called Minister for Home Affairs and DUA 16.
Yes.
It's tab 13 of the materials.
Yes.
The case concerned a circumstance where effectively a migration agent had failed to do any work in support of her clients and used template submissions that didn't reflect the circumstances of their case.
Yes,
to
not
the
this
Immigration Assessment Authority. The ultimate conclusion of the High Court was that it had been unreasonable for the Immigration Assessment Authority, upon receipt of the submission that was, to the knowledge of the authority, the same, identical as other submissions, in other words, template, generic, no details provided. That was obvious. The High Court said it was unreasonable for the authority not to go back to either the applicant or the agent and say, is there actually a proper submission you would like to make? There was no evidence adduced in that case of a hypothetical kind. In other words, if the authority had not been unreasonable, if the authority had come back to me and said, is there actually a proper submission you'd like to make, what submission the applicant would have made, none of that mattered, Your Honour. If I could take Your Honour to paragraph 25 of the High Court's decision. This is tab 13.
Yes.
It's recorded in the first sentence. In this court, the minister correctly accepted that submissions that were made upon instructions from the individuals might have contained new information. Then I jump to paragraph 33, and this more directly deals with Your Honour's point. No issue arises as to the effective materiality upon this legal unreasonableness. The minister properly accepted that it would be a difficult proposition to assert that any coherent and forceful submission that the applicant might have provided could not have made a difference to his case. He expressly disclaimed a submission that a better submission by the applicant could not possibly have made a difference. Here, the proposition is even starker. All of the members in this room have been providing assistance and are now providing assistance to the court to provide a far greater degree of legal clarity about the status of the exemption certificate, how it fit into the landscape, how one construes Section 5.3 of the Biosecurity Act, what the ATAGI guidance says and how it's to be understood, and we say properly understood as suggesting that someone who's recently been infected with COVID-19 ought to get an exemption and so forth. There is an endless list of things that Mr Djokovic could have got assistance from lawyers, Tennis Australia, potentially the Victorian government, self-evidently from the very material before the court, if he'd been allowed a modicum more time, as had initially been agreed, to consult with people who could assist him to understand what was even going on.
Mr Wood, I have made every endeavour, but I think I've lost count of the number of times that the delegate walks into the room, walks out, walks in, walks out. Meanwhile, the camera's churning away, presumably, as I think the delegate told him, others were watching. But by page 24, he's already said, give me till 8:30. And what then follows, I think, from about 6 a.m. is perhaps understandably after 25 hours of interrupted or a succession of international flights and these interviews from 11:30 p.m. to 6 a.m, Mr Djokovic is perhaps expressing a little objective realism, if not frustration, and he says this: "Yeah, I know you're going to cancel my visa. It's obvious." And then he asks questions, and he goes on and says, in effect, I would just like for this another 2-3 hours to see whether or not they can do something. And then he goes on more emphatically, that's the whole idea. Now, all of that behaviour completely undermines any suggestion that the applicant was not serious, in fact determined, if given a reasonable opportunity to do so, to contact Tennis Australia, to contact his agents, to have them contact anybody connected, the professor of immunology, the physician with specialist experience in diseases, the Victorian State Government independent panel, and say, I literally do not understand what has gone on in the last 7 or 8 hours. Will you please talk to these people and respond for me to the invitation I've supposedly been given to tell you why you should consider there are good grounds to decide not to cancel my visa, as you apparently have in contemplation. What other conclusion is available on the evidence?
None. And in due course, Your Honour, I want to pick up, just to assist Your Honour in preparing reasons and making your decision in due course, I want to pick up a number of references where it's abundantly clear that is what he wanted, and that the only basis identified for the reneging of the agreement to allow him even a modicum of time. We're talking about the difference of time between 7:42, when the decision was made, and 8:30. We're covering a few different points here, Your Honour, but I think it's a useful exchange.
It's my fault. I completely understand that, but
no.
You know, the short, fine legal points are very well and good for you and me and Mr. Tran, but persons who are seeking to travel to, enter in and remain in Australia when they have been issued a valid visa, when they have made a travel declaration, when it has been assessed, and when they have been told by the federal government that's okay, when they've been told by the state government it's okay, and by Tennis Australia it's okay, the person sitting in the shoes of the applicant, he's not concerned with the hundreds of provisions of the Migration Act. He just says, tell me what's going on. I don't understand this. If someone can help me, give me my phone back and let's try and get a real response to what you want.
Yes, Your Honour, the point I wanted to make, accepting that we're jumping around between grounds, but dealing with it as a narrative, the point I wanted to make, Your Honour is well aware of the decision of the High Court in Minister for Immigration and Citizenship and Lee. That is the decision about legal unreasonableness upon which modern jurisprudence on that topic has developed.
We spoke about it last Thursday, and we spoke about it because at about 6 o'clock it was clear the applicant wanted till 8:30, and effectively without any notice to him, he's then told an hour earlier, oh look, we've already made the decision. Now, if this case isn't all square within the principles considered by each member of the High Court in Lee, tell me why it's not.
Well, you won't be hearing that submission from me, Your Honour. And in fact, this case is a profoundly starker illustration of the circumstances that led the High Court to decide Lee. So in Lee, what happened was the applicant needed some more time to get a
I'm
skills
familiar with
assessment.
the facts.
Yeah.
You've made your submission.
Yeah. In this case, Mr. Djokovic wanted a matter of hours. The only person who suffered prejudice conceivably from those additional hour or so being afforded to him was him. He was the person who was enduring a prolonged, unpleasant stay in immigration clearance. There was no prejudice, deleterious effect beyond perhaps the convenience of the delegate whose shift was ending to the Minister or the Commonwealth. There was no discernible or rational or intelligible basis not to afford Mr. Djokovic the time that he was seeking, and reasonably so. Your Honour, there are so many ways to enter and explain the vices with this decision-making process, notwithstanding the discussion that we've usefully had. For the sake of clarity and so that I'm making a series of legal points that I do want to make so Your Honour understands them, can I come back momentarily? Yes. Ground 1D. Thank you. So ground 1D, Your Honour, although it doesn't have the same colour and movement, as you like, as the manifest unfairness and unreasonableness of the process, a product of the circumstances that we've been discussing. We come back to point 7, part B, decision record, with a quote, details of the evidence and findings. The point I wanted to make is that quite clearly, one of the cumulative bases upon which the delegate purported to be satisfied that the relevant ground for cancellation existed, what can only be a conclusion by the delegate that Mr. Djokovic had breached Section 5, Sub 3 of the biosecurity determination, that being the only bit of the biosecurity determination that had been notified in the 119 notice. That conclusion was that finding that there had been a breach by Mr. Djokovic, which would, to quote the delegate, be, quote, considered a potential risk to the health, safety or good order of the community itself. In other words, the fact of the breach is just manifestly erroneous. There was no breach of Section 5, Sub 3 of the determination. Indeed, nor was there a breach of Section 5, Sub 7 either, because Mr. Djokovic did give the medical exemption certificate both before he boarded and during the interview with the officer at the airport. And
I understand that.
It therefore readily follows that for that reason alone, that the purported state of satisfaction that the ground existed is impugned. The second point, and this is ground 1C, and one could spend a lot longer talking about 1C. Let me try to be as simple as and as clear as I can, noting the time and the desire for this proceeding to be efficient. Can I take Your Honour to the middle paragraph in point 7, and I'll read it out. It says, unvaccinated persons create a greater health risk of contracting COVID-19 spreading COVID-19 to others, either of which will further burden the Australian health system. Ensuring unvaccinated persons do not enter Australia is a key mechanism through which the Australian government has slowed the spread of COVID-19 within the Australian community. What you observe about that paragraph, Your Honour, is that there's a comparison being drawn between unvaccinated persons simpliciter and vaccinated persons simpliciter. But of course, the whole point of the evidence and the independent panel process and so forth that Mr Djokovic had gone through was that he fell within what you might call a subcategory of unvaccinated persons. That subcategory being an unvaccinated person who had had a recent, not only in the last 6 months, but in the last month, COVID-19 infection that had gone away. So one can't read that paragraph in isolation as possibly supporting the conclusion, because it simply doesn't represent the particularity of the circumstance that presented with Mr Djokovic. He wasn't simply an unvaccinated person. He was an unvaccinated person with a recent COVID-19 infection. And from which he had recovered. And from which he had recovered. And it's a matter that is notorious, Your Honour, and reflects what we all now well understand about epidemiology, is that a degree, at least, for a period of time, at least, of natural immunity flows from being infected. That indeed is why the curve of the epidemic goes up and then goes down. The virus runs out of people to infect. Of course, the natural immunity might subside, but it's the same ultimate mechanism for why vaccination is effective. The body has found a way to beat the virus off for a period of time. One's in a better position. Now, I say all that from the bar table, Your Honour, but it says no more than what the ATAGI guidelines, which I'll come to in a moment, themselves say, which is that ATAGI itself, in its own guidelines, recognise and accept that for a period of at least 6 months, infection from COVID-19 induces a degree of natural immunity that reduces the risk of the person who's been infected being reinfected for a period of time. So if we come back to point 7 of the decision record, that middle paragraph expressed in a way entirely undifferentiated or unfocused on the particular circumstances here, being an unvaccinated person with a recent infection, couldn't possibly support the state of satisfaction in relation to his circumstances. One has to read that paragraph with the last sentence of the preceding paragraph. That proposition is this: previous infection with COVID-19, so says the delegate, is not considered a medical contraindication for COVID-19 vaccination in Australia. What I want to do now, which is round 1C, which is put by us in a number of alternative ways in writing, is to try to make this point as simply as I can. Medical contraindication is an expression that is used in section 5, sub 3 of the biosecurity determination, which we've already looked at.
Yes.
It is not an expression, however, that is defined in either the Biosecurity Act or indeed in the biosecurity determination itself.
Mr Wood, do you accept that it's not a technical term?
I think I do.
So it should be given its ordinary meaning.
Yeah.
Thank you.
Now, I obviously completely appreciate that the exercise involved in statutory interpretation is not simply a matter of looking up the dictionary, but it's often a useful place to start. We have provided in tab 38 of the materials the Macquarie Dictionary definition of the expression contraindicate. Can I invite Your Honour to look at that?
Mr Wood, in this compartment of your case, I've had an opportunity to examine your careful submissions.
Thank you. So for the benefit at least of those who are listening to this or watching this, it says of a symptom or condition to give indication against the advisability of a particular or usual remedy or treatment. So relevantly here, the condition is recent COVID infection, the treatment is vaccination. So in substance, the ordinary meaning of medical contraindication here is advisability against vaccination for someone who has a COVID-19 infection. Now, let me develop it again as simply as I possibly can for present purposes. We come back to point 7 of the decision record. We come back to the chapeau sentence at the top of the page, which invites the delegate to record details of the evidence and findings about why the delegate is satisfied grounds for cancellation do exist. We come to the critical sentence in the second paragraph. Previous infection with COVID-19 is not considered a medical contraindication for COVID-19 vaccination in Australia. That might be characterised, Your Honour, as a finding. You will find nowhere in point 7 of this form any evidence whatsoever for that finding, noting, of course, that, as I've already explained, medical contraindication is not defined in the biosecurity determination. It has its ordinary meaning. So the question about which the delegate made a finding, in other words, is it not advisable, or is there a reason to advise against a person who's had a recent COVID infection from being vaccinated? The delegate says in the passive voice, is not considered a medical contraindication, provides no evidence whatsoever that finding.
Well, you ask by your written submissions, parenthetically, by whom?
Well, indeed. Now, let's say for the sake of argument, considered by someone else and adopted by this delegate, it nevertheless remains the case where was any evidence whatsoever provided for that finding, noting again the very purpose of this box set out the evidence and findings. There's none. Now, reinforcing that is that not only was no evidence identified by the delegate in the decision record, which invites the court to make the obvious inference, it's reinforced by the correspondence between the solicitors that is the subject of Bannister affidavit number 5 that I referred to earlier. I won't bore you on it with the back and forth of the email. Suffice to say, Ms Bannister, as soon as this emergency broke out on Thursday morning and repeatedly over the course of time kept saying, please give us all of the material that's before the decision maker. Responses were given. The evidence is as it is before the court, and one finds no evidence even before the decision maker, let alone recorded in the statement of reasons, that provides rational support for the positive finding made by the delegate that previous infection with COVID-19, not a medical contraindication for COVID-19.
Can I ask another question, please? It is somewhat difficult for me to understand in a circumstance where there is only the medical evidence before the delegate, which is a medical exemption that has been provided, and I use the word emphatically, provided by a professor of immunology and provided by his co-panel member, a physician with expertise in disease, being a medical exemption that has been considered and endorsed by a separate independent expert medical panel established by the state government. What is the rational or logical basis for a delegate who, for present purposes, may be assumed to have no independent medical qualifications to look behind it? I just struggle with this.
There is none, Your Honour. There is none. So to put it quite simply, the delegate, there's no evidence the delegate had any medical qualifications such that they might enable him to form his own view. There was no evidence identified by the delegate in the part of the decision record that invites its expression of evidence for the finding. There is no evidence before the court that there was any other evidence before the delegate that was capable of supporting the finding. What there was evidence of was the very thing that Your Honour has just referred to, which is the medical exemption certificate, which identified two eminent and specialist medical practitioners in this space who were members of the independent panel who decided that fit that Mr. Djokovic should be exempt from the requirement for being vaccinated because he had recently had a COVID-19 infection. So
more emphatically, I'm sorry, not should be, he was.
Yes.
He was exempt.
Correct. So there is simply, whether one views it as a failure to engage with the applicant's evidence, in other words, the opinions of those two eminent medical practitioners, or whether one views it through the prism of making a positive finding that the delegate did without apparently having any expertise to do so and any evidence of a medical kind that supported the finding, the error is once again palpable. Now, let it be assumed somehow, although there's no evidence whatsoever for this assumption, but let it be assumed for the sake of argument that when the delegate used the passive voice is not considered a medical contraindication. The delegate was meaning to refer to the view of Atagi. And let it be assumed, although again, once again, there's no evidence whatsoever of this, that not only was the delegate meaning to refer to Atagi's view, but the delegate had actually read the Atagi guidelines and had a sophisticated understanding of what Atagi was saying in various guidelines. Even then, on that multi-pronged set of assumptions for which, in truth, there is no evidence whatsoever, even then, the finding that the delegate made would be would involve a seriously unreasonable interpretation of what Atagi itself has said. Would Your Honour, at this point in time, that there's a degree of complexity in working through this material, be assisted with my taking Your Honour through the material to explain why that is so? It might take about 5 to 10 minutes. To some extent, Your Honour, I'm aware it's been covered in our written submissions.
What I think would be useful to do in these stages is firstly to inquire of you, Mr. Wood. You, subject to a brief adjournment, which I propose to take now, would have no objection, would you, to continuing to sit on until your submissions are concluded?
No, none whatsoever.
And I won't do it now, but if you could be ready in a minute to inform me of precisely what material it is that you want me to have in front of me so that I can identify that without delay before or during the break. Relatedly, Mr. Tran, is it convenient to you at the moment to indicate the preference of yourself, Ms. Wooden, and your client, the Minister, as to how you would like to put your submissions and when?
I expect, Your Honour, that will depend a little bit on how long Mr. Wood requires, but it sounds like there might be a little bit more. It's probably convenient to take the luncheon adjournment after Mr. Wood completes his oral submissions.
I'm sorry, Mr. Tran. I have tried to make clear to you, both during the hearing on Saturday and with your instructor on Sunday evening, that if in fairness to yourself and your junior, you consider that you want a little more time, would it be your preference to start at 2 o'clock or 4 o'clock or 6 o'clock today, or would you prefer to start tomorrow morning? And I've foreshadowed to those who were at the hearing last night that if it is tomorrow morning, I want to be told today, but I would be proposing to commence that hearing at 9 a.m.
Thank you for that clarification, Your Honour. Perhaps when Your Honour stands me down right now, I'll take those instructions, if the court pleases.
Well, will you, Mr. Trent, I don't want to delay this. I'm thinking about you more than anyone else.
Well, I'm happy to just continue, Your Honour, today.
Today?
Yes. I'll have to obviously revise that after.
No, I understand. All right. Well, look, as long as you're comfortable in your own skin that you've got the ability to proceed today and you don't feel any prejudice, then I will definitely prefer to continue today. But if your instructions are that people, having had the benefit of listening to today's submissions, would like on mature reflection to consider the position of the minister, then that is an accommodation I would be happy to give you.
Indeed, thank you, Your Honour.
The only other thing that I think is convenient at this point to reiterate, as a result of last night's hearing, the parties put in a joint minute of an order which has now been, I think, uploaded. And the order is settled by me in chambers. The point I seek to emphasise is that it will remain the responsibility of the minister for the safe conveyance and presence and return of the applicant to and from detention for the purposes of his participation in the hearing. And what I'm seeking to underline to you, Mr. Tran, and those instructing you, is that means on every day of the hearing, including at the delivery of judgment, whenever that is.
Of course, Your Honour.
Thank you. Now, Mr. Wood, before I adjourn briefly, what is the material?
Your Honour, I think you only need to have two affidavits, Bannister number 1 and Bannister number 4.
Thank you very much.
Bannister number 4, to be clear, Your Honour, is the 37-page affidavit.
Very good. The court will adjourn
The
until
Federal Circuit.
12:30.
The Federal Circuit and Family Court of Australia is temporarily adjourned until 12:30 p.m.
Open the court, please.
Silence. The Federal Circuit and Family Court of Australia is now in session, recalling the matter of Novak Djokovic, the Minister for Home Affairs, for hearing.
Yes, Mr. Wood.
Thank you, Your Honour. Can I take Your Honour back to Batterson number 4, page 36?
Yes.
I'm sorry, I might be saying Batterson is another instructor of mine. Bannister. Bannister number 4, page 36. And we were looking at this before. This is the second page of the Australian Travel Declaration that Mr. Djokovic made. And I take Your Honour to point 9.1.1.
Yes.
See there, again, this is part of the Home Affairs pre-filled form. It says the declare can't be vaccinated for medical reasons. And then it says in the pre-filled form, see proof of medical exemption when coming to Australia. Then you're going to see in square brackets a Home Affairs website. That Home Affairs website is in evidence, and I'll turn to that.
Sorry, I'm sorry, Mr. Wood. Can you do that again, please? Where are you? On page 36, 9 point.
1.1.
Yes.
I declare I cannot be vaccinated for medical reasons. It says see proof of medical exemption when coming to Australia. Square brackets, and there's a website for Home Affairs.
Very good.
I take Your Honour to that website. This is Bannister number 1, page 47.
What exhibit number was it given?
Yeah, it's annexure I.
Thank you very much. I was going to ask you about that.
Yeah. So this is
I have it.
This is the website. Now, if you can go to page 47.
Yes, thank you.
You'll see a heading there, proof that you cannot be vaccinated for medical reasons when coming to Australia. Now, what I want you to know in particular about this bit, Your Honour, is that under that it says, if you are coming to Australia and have and I emphasise, medical contraindication recorded in the Australian Immunisation Register, then you can show a certificate. And the next paragraph says, if you don't have medical contraindication recorded in the Australian Immunisation Register, then you'll need to show airline staff medical certificate. The significance, Your Honour, for present purposes, is the concept of medical contraindication, which of course Your Honour will recall was the subject of the delegate's positive finding in the relevant paragraph of the statement of reasons.
Yes.
Now, the next link in the chain is one goes to, or the next part of the context that's useful to understand the ATAGI position is you go to the form that is used by doctors when they are uploading a record onto the Australian Immunisation Register. In other words, in context to show the existence of a, quote, medical contraindication.
Yes.
That one, Your Honour, is annexure K to the same affidavit of Ms. Bannister. Does Your Honour have that?
Yes.
You'll see this is a form from the Australian Government Services Australia. On the right-hand top side, you see Australian Immunisation Register, Immunisation Medical Exemption. And see at the top left, under the heading, when to use this form, it's a form that's designed to be used by medical practitioners. They're the ones who upload the evidence onto the register, thereby creating the record on the register. So it says use this form if you're a GP and so forth, and would like to notify the Australian Immunisation Register of an individual who has a vaccine exemption due to and I emphasise, medical contraindication. Then we look at the right-hand column of the page at the top.
Sorry, before you leave it, what do you say, if anything, attaches to the words that follow after due to a medical contraindication or natural immunity?
I don't think that disjunctive or natural immunity has significance to the
Thank you.
point
That's
that
all
I'm
I
seeking
need.
to. Yep. If we then go to the top right-hand side of the same page, there's the heading. It says vaccines exempt due to, and again I emphasise the expression, medical contraindication. And then we find the relevant point, which is point 6, and it invites the general practitioner or the doctor to tick a relevant box, pass over the permanent exemption, which is not applicable here, go to the second one, which is called temporary vaccine exemption until a date to be entered by the practitioner, due to a non-permanent contraindication because of the following, and then observe the first box that then appears. Tick 1, quote, acute major medical illness. Now, then turn the page. So I'm now looking at page 3 of this Australian immunisation register form to be used by medical practitioners. And you'll see, if you're looking at page 3 of that form,
Yes.
top left-hand side, there's a heading that says guidelines for immunisation medical exemption. Then the subheading says, what is considered a valid medical contraindication? Again, that same expression that the delegate used in the statement of reasons to immunisation. Yes. Pass over the first paragraph that refers to the immunisation handbook, move to the second one. It says, now we get to ATAGI. The Australian Technical Advisory Group on Immunisation has expanded guidance on, it's called acute major medical conditions that warrant a temporary medical contraindication. I should say that in passing that the word acute that is used in a number of these documents is clearly to be understood by contradistinction to chronic. Acute doesn't mean significant, strong, deleterious effects of some gravity. It means non-chronic.
Thank you.
So acute major medical conditions that warrant a temporary medical contraindication. And then this is the relevant link in the chain, says this information is available on the Department of Health website, which is then given. Now, jump back within the same affidavit. So we're looking at Bannister number 1 and look to the body of the affidavit, paragraph 5J. What it shows is that Miss Bannister accessed the relevant webpage of the Australian Department. Sorry, I withdraw that. It's paragraph, it's 5J. So access the Australian Department of Health webpage at the relevant address, and then I'll take you there. The document that is published there, which that Australian Immunisation Register form is referring to, is the document at Annexure C to the same affidavit. This is the document called ATAGI Expanded Guidance on Acute Major Medical Conditions. Has everyone got a copy of that?
Not yet. Yes.
Okay. So look at the heading for a start. ATAGI Expanded Guidance on Acute Major Medical Conditions that warrant a temporary medical exemption for COVID-19 vaccines. It's dated the 26th of November 2021. It's expressly in the first paragraph stated to support preparation, or in other words, general practitioners and the like, to support completion of the documents that they upload to Services Australia for use on the Australian Immunisation Register, and its guidelines to assist doctors to do that. Then we have the heading background. Then we have relevantly the heading temporary exemptions. Then move to the second paragraph under that heading. It says valid reasons for a temporary exemption include, skip over the first dot point, which is not applicable here. Second dot point, quote, for all COVID-19 vaccines, so not just AstraZeneca or not just Pfizer or the like, for all COVID-19 vaccines, skip over the first sub-dot point, not presently relevant, go to the second one. PCR confirmed SARS-CoV-2 infection where, and this we say is expressed in explanatory language, where vaccination can be deferred until 6 months after the infection. Now, what we say is that, pausing there, this is the critical ATAGI document with the links that we've identified, is an abundantly clear expression by ATAGI being the repository of immunology expertise advisors to the Commonwealth Government, that ATAGI is saying that a valid reason for a temporary exemption for an acute major medical condition is for all COVID vaccines, PCR confirmed infection, and then we say in explanatory language where vaccination can be deferred until 6 months after the infection. Can I pause here and just add some commentary to understand why indeed that advice is unremarkable? This, of course, advice being clearly the advice that was applied by the two panels, including the independent panel that produced the decision, that produced the certificate which Mr Djokovic gave to both to the federal authorities. Reflect back, Your Honour, on the ordinary meaning of medical contraindication, and we provided them a Macquarie dictionary definition, the substance of which is advisability against, in substance, being vaccinated because of recent COVID infection. There can only logically be two reasons, or a combination thereof, why it would be advisable not to take the relevant treatment here, being vaccination. That is because potential risks of being vaccinated assessed with, in combination, potential benefits of being vaccinated. Now, it's utterly unremarkable in light of another document that I'll take you on to in a moment coming from ATAGI, that someone who, and this must notoriously be so, who has had a recent, and ATAGI thinks 6 months is the relevant duration, who has had a recent COVID infection, has therefore acquired at least a degree of what might be called natural immunity. And therefore, vaccinating that person will have at least limited utility. Why? Logically, because they've already got at least a degree of immunisation as a product of having had the infection themselves and thereby built up that immunity. And in any event, inherent in any medical procedure, vaccination being one, is, and again this is notorious, attended by necessarily some risk. I'm not saying the risk is high, I'm not saying many people suffer it, but any medical procedure, including vaccination, carries with it some risk. So it's utterly unsurprising that what ATAGI is saying is that for someone who has had a recent COVID-19 infection, vaccination is not advisable, hence why the advice is it can be deferred for 6 months after the infection, because of either or a combination of the propositions that it will have limited utility because the person, because of the recent infection, will have built up a degree of natural immunity, combined with the inevitable risk associated with any medical procedure, including vaccination, of some kind of adverse effect. Can I take Your Honour to the final document? It's another ATAGI document. This one dated the 14th of December 2021, and it is Annexure B to the same affidavit.
Yes.
Now, this document is less relevant than the one that I've just taken Your Honour to. The one that I just took Your Honour to, of course, is the very document that GPs are exhorted to apply as guidance when making assessments about what to put up on the register, which, of course, when you track back through the links in the chain that I've just taken Your Honour through, the point of which ultimately traces back to the Australian Travel Declaration, whether or not one's got a medical contraindication to COVID-19 vaccine. This second document, which is dated the 14th of December 2021, is not as directly relevant because it doesn't form a link in that chain, and moreover, it deals with a slightly different subject. The subject with which this document deals is, as the heading states, the definition of, quote, fully vaccinated. Now, to be perfectly clear, it is no part of Mr Djokovic's argument to this court, or indeed the case that he presented to the extent that he was allowed, to the officials at the airport, that he's fully vaccinated. Fully vaccinated, as explained by ATAGI, is having had a relevant number of doses of a certain number of different kinds of vaccine as they're set out. And so at the bottom of that page, we have the heading TGA approved and recognised vaccines. We can skip over that because that's not relevant here. Mr Djokovic is not vaccinated. Then we move to page number 2, or it's page 10 of the affidavit. It's headed Special Considerations for the Definition of Fully Vaccinated. There's a series of subheadings, the first few of which are not relevant. Then on the next page, we have the subheading Past SARS-CoV-2 Infection. And it's the first paragraph here that picks up what I was indicating to Your Honour earlier about what ATAGI has said is accepted as the effect of having been infected with COVID, which is that one acquires a degree of natural immunity for a period of time. So
I'm sorry, Mr. Wood, where are you?
Page 3 of the 14 December 2021 guidelines.
Yes, thank you very much. Past
Top
infection.
page, subheading under the broader heading Special Considerations for the definition.
I have it.
Subheadings past COV-2 infection. Look at the first paragraph. ATAGI notes that natural immunity from past infections is recognised as fully vaccinated in several European countries. ATAGI also notes the challenge of confirming past infection, in other words, as a matter of fact or as a matter of administrative practice, and uncertainty with regards to the duration of protection. But pausing there for the moment, whilst ATAGI is observing that it is recognised in other European countries as relevant to the definition of fully vaccinated, what presently matters is ATAGI's acknowledgement or recognition that natural immunity does flow from past infection. The doubts that ATAGI expresses about it, the challenge of confirming in a given case whether someone has in fact had a past infection, is the first point. And the second doubt is uncertainty with regards to the duration of protection. But it's abundantly clear that ATAGI is saying that having had a past infection provides, subject to questions about duration, natural immunity. Then we go to the second paragraph. It says, while evidence suggests that past infection reduces the risk of reinfection for, quote, at least 6 months. So that links with the duration doubt expressed above. ATAGI is saying evidence suggests that past infection reduces the risk of reinfection for at least 6 months. And then we get to an important bit, brackets, and therefore may be regarded as a temporary exemption for vaccination for a maximum of 6 months, which of course perfectly coheres with the 26 November 2021 document that we explored earlier, which is the ATAGI expanded guidance on acute major medical conditions, which with crystal clarity identified PCR confirmed infection within the past 6 months as being the basis for the grant of a temporary exemption. Now, what Mr. Tran and Ms. Wushan emphasise is the balance of that second paragraph, where it said ATAGI recommends that 2 doses of a TGA-approved vaccine is still required to be considered fully vaccinated, but that's of no concern because no part of Mr. Djokovic's case is that he's fully vaccinated, and indeed the delegate made no findings about the question of full vaccination with respect to Mr. Djokovic. What Mr. Tran and Ms. Woodner emphasise is the final sentence in that paragraph, which says past infection with SARS-CoV-2 is not a contraindication to vaccination, but that has to be understood as a general statement qualified by what ATAGI has said with abundant clarity in the 26 November document that recent, the subcategory recent past infection is, which of course also coheres with what in the preceding paragraph ATAGI is accepting that recent infection produces, which is a degree of immunity. In any event, what we identify, Your Honour, is on page 4 of this document, which, as I emphasise, is the less important of the ATAGI guidelines. So if we move to the next page, page 4, there's a subheading that says past SARS-CoV-2 infection. And entirely consistently with the 26 November guideline document, the first paragraph says COVID-19 vaccination in people who have had a PCR-confirmed SARS-CoV-2 infection can be deferred for a maximum of 6 months after the acute illness as a temporary exemption due to, quote, acute major medical illness, which is necessarily to be regarded as a medical contraindication to the taking of the vaccine. How else could an acute major medical illness be characterised, and how could the reference there be explained otherwise than it is, in the circumstance of a recent infection, a medical contraindication to the taking of a vaccine? Now, the next paragraph acknowledges, I think it's fair to say, that people with a past infection can start their vaccination course or complete their second dose if they've already had a first dose prior to being infected, and makes a recommendation of the minimum interval. But that doesn't cut across the proposition, which is clearly put in the first paragraph, that it can be deferred as a temporary exemption due to acute major medical illness. That then leaves the final part of the puzzle, which is the table at page 5, the same guideline, which sets out scenarios, doses, and ultimately clinical recommendations in the right-hand column. The relevant entry is the final row, left-hand column, scenario, previous infection. Then if we move to the third column, which is entitled number of doses received, look at the first bit of that final row, none. That's the case here with Mr. Djokovic. The fourth column deals with the subject with which we're not concerned. Doses required to be considered fully vaccinated. Atagi's answer is, well, 2 doses. Fair enough. Mr. Djokovic doesn't say he's fully vaccinated. That's not the point. But we move to the relevant bit, which is the final column, clinical recommendation. In other words, advisability, picking up that notion of what medical contraindication means. Recommendation, what's the answer? Valid exemption for up to 6 months. And then we have a hashtag, in effect operating as a footnote. One moves to the bottom of the page. The hashtag says, more information can be found in Atagi expanded guidance on temporary medical exemptions for COVID-19 vaccines, which is, of course, the 26 November 2021 document that I was just exploring, which is, of course, the more relevant document that says with abundant clarity that for all COVID-19 vaccines, PCR confirmed infection where vaccination can be deferred until 6 months after the infection. So, to put that all in the picture of this case again, Your Honour, I remind Your Honour that the simple point on ground 1C, and it's a very simple one, that I've already discussed, is that the delegate made a positive finding that previous infection is not considered a medical contraindication. I've explained that there was no evidence identified in the reasons for that positive finding. There's no evidence before the court that there was any other evidence before the delegate that was capable of supporting that finding. I've explained to the court that the only evidence that was before the delegate was evidence that came in the form of the exemption certificate from Tennis Australia that referred to 2 eminent physicians with specialist expertise who had expressed the view that the exemption should be granted based on Atagi guidelines. And I've said that therefore on a just vanilla analysis, application of administrative law principles, the positive finding wasn't open, and the failure to deal with the applicant's own evidence itself reveals jurisdictional error. The point of this discussion about Atagi guidelines is to say, even if somehow, despite the absence of evidence, despite the minister not calling the delegate as a witness, even if somehow we're to understand that in the absence of evidence, that indeed the delegate was deeply familiar with the Atagi guidelines, he'd read them, he'd considered them, and so forth. And it was those Atagi, in other words, expert guidelines that were providing the foundation for his positive finding. It would involve a clear misunderstanding of the effect of those guidelines, which is that the recommendation is made of the grant of an exemption if the COVID-19 infection was within the past 6 months. Now, in a sense, all of that probably goes by the by, because it's simply not the basis upon which this delegate made their decision anyway. There's no evidence for that. Instead, we just have a bold positive finding of fact for which no evidence was provided and which was contradicted by the only evidence that was before the delegate, that coming from Mr. Djokovic and ultimately the eminent physicians that I've referred to on a couple of occasions. Your Honour, as for authority, I don't take this to be an issue. I'll just mention that I won't take Your Honour to it, but ample full court, federal court authority to the proposition that even where policy guidance is not a mandatory relevant consideration, that where a decision maker does choose to rely on such policy guidance but gets it seriously wrong, that can involve jurisdictional error. The most relevant case, Your Honour, is the decision of the full court in a case called Gray, which is a migration case. It's tab 19 of the materials. The relevant quote is at page 208 of the judgment. I'll just read it out because it's very short. The full court says, if a decision maker not bound to apply policy purports to apply it as a proper basis for disposing of the case in hand, but misconstrues or misunderstands it, so that what is applied is not the policy but something else, then there may be reviewable error. So that completes, Your Honour, in a lot longer period of time than I might have originally expected, our analysis of grounds 1C and 1D in terms of why the delegate erred in purporting to form a state of satisfaction, which is what point 7 of the decision record concerns, that indeed Mr Djokovic does indeed pose a risk to the safety or health and safety of the Australian community or a segment thereof. Can I much more briefly now deal with grounds 2A and 2B? They concern the second distinct discretionary phase. Can I locate again where that comes up in the decision record? It comes up in a different point of the document. So we've been focused so far on point 7. What I want to invite you on now is to turn the page. So we're now looking at Bannister number 1, page 47. Yes. It says there's point 8, and performing a similar function to which point that set out with respect to the ground analysis. In point 8, the delegates invited to provide a summary of the reasons that Mr Djokovic gave for why the visa should not be cancelled. So the words should not be cancelled are properly understood here, as now we've moved past the question of does the ground exist, and now we're in that part of the document that deals with whether the discretion should be exercised, assuming the ground exists. In other words, assuming that it's open to the delegate to be satisfied that Mr Djokovic does pose a risk to the health of the Australian community. And there's a number of propositions reflecting points that Mr Djokovic made. I'll come to the transcript in a moment. The first and important point I want to make about this part of the form is this. In point 9, it says delegates' assessment of the reasons the visa should not be cancelled. And what one sees is a pre-printed set of boxes that silos, or is apt to silo, the approach that the delegate takes to the task of considering the exercise of discretion. So the first box with the pre-printed text is purpose of travel to and stay in Australia. And in substance, the delegate, when considering that question, made a favourable finding. Says purpose was it was a compelling need, indeed, for Mr Djokovic to travel to Australia to participate in the Australian Open. The second box with the pre-printed text says extent of compliance with visa conditions. And again, a favourable finding is made. Mr Djokovic has a compliant travel history with no evidence of non-compliance with visa conditions. Then we get to the third pre-printed box, the degree of hardship which may be caused to the visa holder, their family members and so forth. And the delegate generously acknowledges that the cancellation decision would, quote, likely result in a reasonable level of inconvenience to Mr Djokovic. Then we get to the next page. The pre-printed box is now client circumstances in which ground for cancellation arose, and importantly, brackets, whether there were any extenuating circumstances beyond the visa holder's control that led to the grounds existing. That's important. I'll come back to that in a minute. Ground 2B, Your Honour, is essentially a complaint that the delegate, and it's a simple point. I don't need to go much beyond what I've said in writing. The delegate, bizarrely, concluded, only addressed here whether there were extending circumstances beyond Mr Djokovic's control, said that there weren't because whatever he got from Tennis Australia reflected material that he gave Tennis Australia, therefore says none of this is beyond his control, but therefore, bizarrely, says therefore the delegate applies significant weight in favour of visa cancellation. And as we've said in writing to the Woodville High Court Authority, the absence of extenuating circumstances can rationally only be neutral. It cannot provide positive support for the exercise of an adverse power, which here was cancellation. That's ground 2B. I need to say no more about it. It's extremely simple. The next box is visa holder's behaviour in relation to the department. And there's a favourable finding made. This has been cooperative throughout the process, implicitly accepting that he'd been honest and cooperative in his interview with the delegate. Then finally, we get to the box which would have been the box for the delegate to deal with the representations that Mr Djokovic did make, but the delegate didn't do so. Why? Because this box is entitled Other Relevant Reasons. And it would be here in the form, Your Honour, where if Mr Djokovic had presented evidence and submissions saying, in effect, why, even if the ground exists, the visa should not be cancelled, that the delegate would have to deal with that. Recall, as I said at the start, Your Honour, and as is common cause between the parties, the whole point of the 119 notice and 1191 paragraph B, Roman 2 in particular, is to give the visa holder the opportunity to explain that even if the ground exists, why nevertheless the discretion should not be exercised to cancel. And it would be absurd if such evidence and submissions are indeed made, but then they're not considered before the decision is made. But the short point, Your Honour, here is that Mr Djokovic quite clearly, and given the time, I won't be as laborious going through the transcript as I was otherwise inclined to be, but quite clearly, repeatedly was saying, you should not cancel my visa, A, because I got the medical exemption from the panel, not the mere fact of having got it, but the content of it, what it signified, representing the expression of ATAGI guidelines. But moreover, and what I wanted to emphasise is, repeatedly Mr Djokovic referred during the interview with the delegate to the fact that he had received the assessment document from the federal government. Recall, Your Honour, that was the document that came from the federal government, that upon receipt of the exemption certificate from Tennis Australia, the federal government said your declaration's been assessed and your responses indicate you meet the requirements. And what Mr Djokovic was repeatedly saying, we can provide a note later with transcript references, I'm conscious of the time, but numerous times throughout the transcript, Mr Djokovic is saying, in substance, I made the declaration and then I got back from Home Affairs a document indicating I had been assessed as meeting the requirements. So in substance, what Mr Djokovic was saying was, please do not cancel my visa, do not exercise a discretion to do so in circumstance where everything that I've been led to believe from Tennis Australia, from the product of the independent medical panel, but moreover critically for present purposes from the federal government itself, has told me I'm in the clear. And so even if, in other words, it was open to the delegate, contra all of the arguments I've made so far, to conclude rationally, which it was not on the evidence before the delegate, that Mr Djokovic posed a risk to the health of the Australian community, or that his recent infection was not a medical contraindication of vaccinations as it plainly was. Even if the ground existed, in other words, Mr Djokovic was saying, given everything I've been told by everyone, please don't, in the particular circumstances of my case, when I'm here for a limited purpose to compete in an elite tournament, and I'm utterly confused as to why I'm in this situation, and no one told me anything about it, please don't cancel my visa. Please don't exercise that discretionary power. Nowhere does the delegate, in the reasons that are given, engage at all with that substantial and understandable submission and appeal and plea that was repeatedly being made by Mr Djokovic. But the part of the form where that would have to be contained, if it had been considered, is this one, because it's other relevant reasons, and it's simply not discussed. Instead, the delegate confines himself to noting summarily a set of legal consequences that Your Honour should understand, meaning that if this cancellation decision is not disturbed, just so Your Honour completely understands the situation, he will be subject to a bar under 48 for applying for certain kinds of visas, but moreover, by operation of certain provisions in Schedule 4 to the migration regulations, will be unable to get any visa to come back to Australia for a 3-year period.
Yes, I do understand the force of that.
All right.
That is set out in the notice that was given to the applicant.
Yes, and so Mr Djokovic is essentially saying, pleading to the delegate, in the circumstances, given what I've been told, don't do it. But it falls on deaf ears. It's not discussed. It's not evaluated in any active intellectual way. The final part of my submissions, Your Honour, concerns procedural fairness and unreasonableness. I think I can do it within about, particularly in light of the discussion that Your Honour and I have had in the running about those matters, in about 20 or so minutes. Would Your Honour like me to proceed on that?
Mr Tran, is that convenient to you?
Yes, it is, Your Honour. Thank you.
Thank you. Well, Mr Wood, if you're content to continue, I would be grateful if that can be achieved within the time you've indicated. The parties have set out in detail their positions about these grounds.
Thank you. And largely, I think what I can usefully do, given what we've already said about legal principles, and both in writing and to some extent orally today, largely what I want to do is take Your Honour through the bits of the transcript when you read it together with the affidavit of Mr Djokovic that I wanted to bring to Your Honour's attention. At the outset, and I think I understand that Your Honour knows this, but just for confirmation, Mr Djokovic's affidavit records at paragraph 18, and of course there's been no cross-examination, no attempt to contradict anything that Mr Djokovic has said about his experiences at Melbourne Airport. What he says at paragraph 18 in the final sentence was that The voice recorder, which is what has been the basis upon which the transcript has been produced, was used throughout the night on occasions when I was being formally interviewed by the delegate, but not during every conversation I had with him or other Australian Border Force officers. So to understand what happened as the hours transpired, one has to...
I've read that evidence.
Thank you. Can I take Your Honour through the bits that I think are highly significant to the unfairness/unreasonableness complaints? Can I start with the transcript, Your Honour? And I'm doing this chronologically, but picking out the high points. Can I take Your Honour to page 11 of the transcript?
Yes.
Line 49. Mr. Djokovic says, and this is at about 3:55.
Yes, I've read that.
Yeah, so that runs from line 49 through to line 5 on page 12. I would encourage Your Honour to read that. On the same page...
Can you work from an assumption, please, Mr. Wood, that I have examined this in its entirety, but that isn't to suggest that I won't be assisted by you reminding me of the particular passages upon which you would have me focus?
Yes, that's all I'll do then, Your Honour, and I won't read it out given
yes,
the time.
Thank
so
you.
I would invite Your Honour to highlight, if you like. We're inviting Your Honour to read carefully. Page 11, line 49, through to page 12, line 5.
Yes.
Page 12, line 17, through to line 31.
Yes.
Then if we jump forward in time to page 17, line 1 through to line 15.
Yes.
Then I would take Your Honour to page 18. I would invite Your Honour to look at lines 1 through to line 6, as well as lines 17 through to line 21.
Yes.
Then I would take Your Honour to page 20. I would invite Your Honour to look at lines 47 through to the end of that page, and all of the way through to line 23 on page 21. Sorry, Mr. Hartley reminds me, I probably also would have ought to have identified, Your Honour, on page 20, have a look at lines 25 through to 33.
Yeah, yes, which I have.
Thank you. Then, if we then move to page 22, this for the sake of those listening, we're now at 5:20 a.m. in the morning. So at page 22, have a look at particularly lines 28 through to, on page 23, line 9. And it's that particular part for note where the delegate indicated that he was going to be finishing his shift soon and the case was going to be handed over to another team. Now, that didn't happen, but what also didn't happen was the original agreement to allow Mr. Djokovic until 8:30 was not adhered to. So that's a bit of interesting context. Then it's at this point, so that exchange finishes at 5:22 a.m. You can see that at line 14 of page 23. It's at that point in time, to understand the matter chronologically, that one has to now go back to Mr. Djokovic's own affidavit, because now the tape's off. And if we look at paragraph 23 of Mr. Djokovic's affidavit, read paragraph 23 and 24 of Mr. Djokovic's affidavit in their entirety, the substance of which was, while the tape recorder is off, initially approached by two of the delegate's superior officers, given the peculiar advice that it was somehow in his interests not to speak to his lawyers at Tennis Australia and so forth. And it was better for him if they just made a decision. And then paragraph 24 concerns the subject of him being, Mr. Djokovic being woken up by the delegate and one of his superiors, presenting to him that it was, quote, better for me if the interview was done right away. and again, consistent with the proposition, putting the pressure on him to just subject himself to the decision being made rather than obtain the support and the assistance of those who might otherwise have advised him before a decision was made. So that's 23 and 24, which are off record. Then we come back to the transcript, and we're back on page 23 of the transcript. And so now it's 6:07 a.m. and I would invite Your Honour to look at lines 32 to 37 in particular. That's the exchange I think that Your Honour pointed out to me earlier, and that is effectively where it ends. The decision is made shortly thereafter. What clearly emerges from all of that, and what I've really discussed with Your Honour, is that it was abundantly clear throughout that whole process that Mr Djokovic wanted more time, at least until 8:30, to speak with his advisors, his agent in Australia, to understand what was going on, to see if there was anything with the assistance of those persons and bodies that might be said in his interests to put against the suggestion that his visa was going to be cancelled. Point 2, that was initially acceded to, and it was agreed that he would be given until at least 8:30. Then, point 3, that agreement was reneged upon. The only basis upon which that 180-degree turn was adopted by the officers, as evidenced in the material, was the entirely spurious suggestion that somehow it was in Mr Djokovic's interests if they just made a decision and he didn't talk to anyone who might otherwise support him and assist him to make submissions against why they shouldn't cancel his visa, and perhaps the suggestion of the practical concern of the delegate's shift being about to end, which could possibly provide a reasonable basis to make the decision when it was made. Very briefly then, Your Honour, as to law, we've run this point obviously in two different ways: fairness and reasonableness. They're distinct concepts, obviously, although they can cross over in their application. As to fairness, all I wanted to say, Your Honour, is briefly, this is the one point of legal dispute between the parties that I adverted to at the start of my submissions. If I can invite Your Honour to look at the Act, section 124, sub 1, paragraph A. Section 124 is headed.
I am sorry. Reached that point in the case. 124.
Yeah. So section 124 has the heading, when decision about visa cancellation may be made. That's part of the partial code of the Natural Justice Hearing Rule.
Yes.
And it says that the Minister may cancel a visa at any time after notice is given under 119 and after whichever one of the following happens first. Now, what's emerged is that Mr Tran, Ms Wooten and our team are in agreement, having regard to legal principles, that here B didn't occur and C is inapplicable. C is inapplicable because this was not a time-bound duration process. That's because the delegate exercised power under 121 to invite the response to be given at an interview, which is not a period of time that is bound by a period. So the only issue between the parties, Your Honour, is whether or not by the time that the decision was made, which I think was at 7:29.
Yes, notified.
7:29 notified to Mr Djokovic at 7:42. I think I made an error about that earlier. So a decision was made at 7:29. The question is, under 124 of the Act, at 7:29, is it the case that the holder had, quote, responded to the notice? And the dispute between Mr Tran and myself is essentially this. Mr Tran submits, as he did last night in writing, that respond there can't mean, in effect, complete response. It just means a response. And we say that is obviously not so, and indeed, were it so, it would generate perverse consequences, because a visa holder might be, in effect, partway through saying what they want to say about why the ground doesn't exist and why the discretion shouldn't be exercised if the ground does exist. And the minister might say, I've heard enough, you have responded in part, I'm now going to make a decision. Obviously absurd. The way that Mr Tran tries to ameliorate that perverse consequence of his interpretation is to say, it's okay, because principles of legal reasonableness kick in. And of course, the minister couldn't, or the delegate couldn't, without contravening, would have to adhere to the principles of reasonableness in deciding when the minister thought that the applicant had responded, whether he'd heard enough. The problem with that is it conflates very different concepts of fairness and reasonableness. Mr. Tran's submissions are at pains to point out the very broad decisional freedom that he adverts to the cases speak of when it comes to reasonableness and the wide discretion that decision makers have and so forth. And so what he's really, the effect of his submission is really this, that the minister has a wide discretion, understood in that reasonableness sense, as to how long they're going to listen to a visa holder. What that does is it transforms a right to due process, a right to fairness, to make a response, into a discretionary power of the minister to how much a response someone is in fact going to get. We say that's wrong. The right way to understand 1241A is that the holder will have responded in this circumstance where the response was to be given at an interview, because that was the mode selected under 1211B of the Act, when in effect, during the interview, the visa holder has indicated that they have said all they wish to have to say. And the analysis is not assisted by extreme or distorting possibilities. Mr. Tran says, oh, well, couldn't the visa holder just filibuster, potentially forever? Well, that's the very kind of distorting possibility.
Can I ask a question on the facts of this case? Wherever the parties might find themselves in some dispute about whether, in a particular case, an interviewee was filibustering or just being intransigent, but effectively putting a stake in the ground and maintaining I haven't finished and you're not going to be able to do anything until I tell you I have, or perhaps in a different situation where a delegate acting quite reasonably says, look, is there anything further you want to say, or have I understood your submissions? In the objective facts of this case, the situation in which these grounds are being pressed are those disclosed by the transcript, namely that it seems uncontroversial this interviewee wanted until 8:30.
And he expressly identified he wanted to speak to particular people and organisation before he could meaningfully respond, because he was essentially saying, I have no idea how this could have come to pass given the advice I received from Tennis Australia, the state government, the Commonwealth government. And to meaningfully respond to what you're putting to me, I need to speak to those people. And so Your Honour is absolutely right to ignore distorting possibilities and focus on the facts of this case. And ultimately, it's a question of characterisation. Is it or is it not the case in the circumstances that presented here and the evidence before the court that Mr. Djokovic had responded? And the answer to that is no. He had started to respond. He wanted to say more, but in order to say more, he needed to speak to certain people and certain organisations, and that opportunity was denied him. And therefore, it follows that there has been a breach of 124 sub 1 paragraph A, which is part of the partial code of the Natural Justice Hearing Rule, and that would be a sufficient basis upon which my client could succeed. In the interests of time, I'll rely on what I've said in writing about WZARH type analysis invoking general law concepts of fairness that survive the partial codification in the Act, and I'll move just very briefly to speak about unreasonableness. I really have covered this before in the discussion that I had with Your Honour about Lee, and this being a circumstance where there was simply no intelligible basis other than ones that can't be justified, the convenience of the shift ending of the delegate or the manifestly perverse advice given to Mr. Djokovic that was in his interests for a decision to be made before he spoke to his advisors. There was no reason, no intelligible reason not to allow him that more time. And so this case is one of the starkest I've ever seen for the application of the principle articulated by the High Court in Lee. And for that reason, it would readily be impugned on the basis that, irrespective of questions of fairness, the conduct of the delegate and the officers was unreasonable. They are my substantive submissions, Your Honour. I just want to say two things which I can do in about 1 minute. First of all, on the question of relief, if Your Honour is persuaded there's been one or more jurisdictional errors, Your Honour would quash the decision Your Honour would not remit the matter because there's no duty that